Oh, give.
My lord, I have mentioned the matter, item number 175. Just Tuesday, I have mentioned, your lordship given liberty to mention on Monday. My lord, lordship kindly 2014 matter, old hearing, my lord, item number 175, lordship kindly update it and fixed a date.
Don't worry.
My lord, may
Give.
my lord, may permit to mention this matter. This matter appeared before lordship on 14 February 2025. We appeared and argued before lordship, but our name has not been incorporated, my lord.
My lord, may I be permitted mention?
No, bhai.
My lord, may I be permitted to mention one old first appeal, my lord, hearing matter, my lord. The earlier, my lord, I mentioned the matter. Your lordship asked me to mention it.
May I be permitted? The assigned matter, residuary matter, or Chief Justice was kind enough to release this matter, not in the lease matter. We are really only avocation.
Whatever.
With kind leave of the Honorable Justice Procedural, may I pray for leave of your lordships, my lord, to mention one assigned contempt. Sitting with my lord, the Honorable Justice Sampa Sarkar. And my lord,
Let us see.
My lord,
সরকার ম্যাডামের সঙ্গে কথা বলে নাও
my lord, may I be permitted to mention on August 2024, my lord, your lordship heard the one assigned matter along with your lordship direction. The other 4 matter along with appear after 2 exchange.
My lord, may I mention for my typographical correction?
Typographical correction দেখে নাও. Have you indicated what is
Yes.
With leave.
Lordship for inclusion.
Take up. Anyhow,
Lordship
for ceremonial purpose, at least you can say something to your client. Don't worry.
Lordship may be allowed for mention for inclusion. For the inclusion, Lordship.
Give all the slips. Give.
May I be lordship?
Give all the slips. Give all the slips.
Application, your lordship for inclusion.
Please pass on all the slips.
My lord, I would like to trouble your lordship, my lord, only on the issue, my lord, the contempt application is pending, my lord. My lord, my lord, my lord.
Pass on all the slips.
My lord,
Everybody, please pass on.
my lord.
With kind leave of your lordship.
Please pass on the.
I'm mentioning one single bench matter before my lord Justice Biswas, my lord. Your lordship has been fixed on contempt matter today, my lord, at 10:30. There was a direction of a personal appearance.
Oh,
Alleged contempt is present before your lordship. Lordship are able to sit or not, no, that is why I'm mentioning, my lord. Your lordship, my lord, these are, we can, my lord, my alleged contempt can, my lord, give his appearance before the learned registry. If your lordship desire.
And my also single bench matter, my lord, contempt application.
Do one thing.
At 1 p.m.
1 p.m. my brother will sit singly. Yes. And this for the contempt matter.
Yes.
Yes. Supplement.
Not fine.
I'm giving that.
TLS contempt to be there at 1.
Yes.
Let for inclusion one content application passed by your lordship for inclusion, single bench matter.
Give.
Item number 228 of your lordship's list, my lord. My lord, only thing, my lord, the application is not appearing in the list, my lord. Let it appear. Let it appear as to be mentioned, my lord, tomorrow, so that my lord.
Application ki ache dekhe na. Yes, call the list. Yes, to be mentioned why? কোথায় আছে?
Lordship, for the applicant wife, I beg to appear on behalf of the alleged contender, Lordship. There was a rule that was issued and the matter was supposed to come on Friday, but since your lordship were not sitting, the contender gave his presence before the learned registrar general in charge, my lord. Yes, my lord.
The contender is here.
No, lordship, the difficulty is that he stays in Bangalore. Since we were in a confusion regarding those strike, he will be present before your lordship tomorrow itself. My lord.
Much obliged.
Great.
My lord, I have for the debate. I am for the defense, my lord. I have been president since 2008.
Let us see what has happened, what you have not done.
Applicant has not taken any step.
Whatever. Let us see.
আরেকটা portion আছে না?
The defects as pointed out by the stamp reporter is not removed within 2 weeks from date, the appeal shall stand dismissed.
Malan, item number 4, Malan. I'm appearing for the appellant, led by Mr. Bandyopadhyay, Malan. Malan, last occasion, Mr. Malan Kollan Bandyopadhyay, senior advocate, Malan.
I heard Gangopadhyay.
No. Nice. Malan, last occasion, Malan, Mr. Bandyopadhyay completed his submission, Malan. Man, only to recap this issue, Malan, kindly see the impugned order at page 663, Malan. At
For the other side,
Lordship, in this matter, Mr. Torun Jyoti Tiwari will appear virtually. Lordship.
My lord, yes, before placing this impugned order, my lord, there is Mr. Actually, আছে তো? করুন। একবার গিয়ে ওখানে একটু বলো না। Sir. Just to impugned orderটা বলছেন।
Regulation note.
Sir, we fast statute.
Fast statute regulation. যেটা দিয়েছি
যাদের
যেটাতে
কাছে
এক্সামিনিং অথরিটি যেটাতে রয়েছে
ওটা আমাদের রেগুলেশন এডুকেশন রেগুলেশন স্যার ওকে দেওয়া আছে স্যার
কি করবো আমি একটু 5 মিনিট টানবি
স্যার
3 মিনিট
স্যার
হ্যাঁ
স্যার
যাচ্ছি
yes.
But just to recap this entire case. Lordships have gone through this order impugned, my lord, judgment impugned in this petition. My lord, I just spoke to Lordships. Read petition, my lord, kindly come to first, my lord. Page 51, 27th June 2019. This is Government of West Bengal has issued no objection certificate in favor of Gitanjali College of Pharmacy for this course.
Yes.
Then, my lord, kindly come to page 52. This is the no objection by the university. No objection certificate has been issued by the university.
56 is the
Page 52, sorry, Miller, page 52. I'm very sorry. Page 52.
52.
52, my lord.
Yes, that you have already placed.
Yes, I have already placed already.
Yes.
Just I am reminding you, Lord.
Yes.
Now, my lord, ultimately 6 September 2024. This is approved by the Pharmacy Council of India. Page 53.
53.
Yes. And kindly similar approved up to 2024-2025.
Yes.
Now, my lord, kindly come to 55. And after the approval has come, earlier no objection has been given, then started, these are the deficiencies you are there. This is the university. Page 55.
Yes.
Now, my lord, inspection report deficiencies there. My lord, despite that, we have given the compliance report, page 57. Now, my lord, writ petition was filed on 30th September 2024. Then on their invitation on 4th October 2024, learned single judge have passed an order, go and make the inspection to the university. And I will show to your lordships, university has no power to inspect even. First order. Once approval has been given by the parent council, then no one can stop it. Approval of the parent council is final. They have to do it in accordance with the approval. If you have any objection, you go and objection for next year. I'll show that, my lord. Now, my lord, that is there in invitation. Then, my lord, report of university has been filed at page 118.
Then
118.
180.
118, my lord.
118.
118.
The affidavit.
Report.
Oh.
Report in the shape of the report of university as filed. I am coming with a very short, just for the remind to your lords. Then, my lord, again third order has been filed. See, learned counsel for the university submits, my lord, that is at page 124. Learned counsel for the university submits that due to paucity of time, the university could not arrange for experts for effecting the surprise inspection. Where from this idea is being brought? As directed, there was some intervening holidays, the university as well. Again, direction that you file it in inspection. You do the inspection.
Yes.
Then we'll have fourth order, 28 November 2024. This is at page 126.
Yes.
Inspection report filed on behalf of the university. Take a let an exception in this regard for file the College of when the matter will appear under this and so. Then we have filed our exception report even. That's at page 130. I have shown to your lordships. The paragraph 8 I have shown to your lordships earlier. Kindly mark that one, paragraph 8. Every question's answers have been given. Paragraph 8 of that, that is at page 133.
Yes.
Then, my lord, 9th December 2024, order of this High Court. That is, my lord, September, 9th December, Hardinal will list the matter for hearing. This petitioner shall also produce the records. Page, my lord, 307, sorry. 307 is in which volume? 307? One volume.
This is 300.
Second volume.
Volume 2.
Volume 2.
Yes.
Then, yes, shall also produce the records regarding appointment of faculty made pursuant to the notice that they have relied upon to their exception of this so and so.
Correct.
Then, a supplementary affidavit was filed by us. 302. 309, sorry. Everything has been recorded there. Come to paragraph 10. 9 new faculty members to and the 5 assistants joined in the petition college in the October, November for selection of both the faculty members. Proper procedure has been followed. 9, 10, 11. I have stated everything, Milord. Just to remind to your lordships, kindly recollect that 37 they were saying, I was saying 37 on the day of inspection they went, they have found 32, therefore it is not there. But someone on leave, someone or in the marriage ceremony, I've given the card, marriage ceremony cards also, that your lordships have seen that also.
Own marriage.
Own marriage.
Right.
Strength would be decided on the day of inspection how many persons are there.
How can we stay so rigid on the
Yes.
marriage of a particular gentleman?
So rigidity, I am showing to your lordships. Now, they don't have any business to do it. I will show that.
No.
Usurps their jurisdiction. Now, kindly see staff. Faculty, kindly come to faculty details. I have given the faculty details at page 317. I am not required to show it even. Even then, I am showing it. The point I will be arguing, I am not required to. They are busybody to say all these things.
Yes.
Faculty details, staff verification by the university. Then will kindly come to 15 September 2024. PCI sent advice to all colleges. That is the 15 September to the Pharmacy Council of India is sending letters to all colleges. What is the tenor of the letter? All the universities. Kindly see, my lord, all that letter. Page is at page, my lord, 657. Volume koto? Third volume. 657. Milord, 15 September 2024. Kindly come to Milord. First, second, third, fourth paragraph. The council has received various representatives from institutions across country that admissions making authority has not started admission process for those institutions which are already approved by PCI for 2024-25 academic session. In the light of the above, the council requests all admission making authority to start admissions process to those institutions which are already granted approval by PCI for 2024-20 academic session. Despite that, they have not done it. Now, my lord, lordship, kindly come to my lord. We have made an application for this semester. My lord, I am coming on just on the point of law. Section 10, kindly come to section 10 of the Act. Pharmaceutical Council of India, Pharmacy Act. They are showing this session. They have said on the other day, June and January. Session. All admissions were completed in October. I will show to your lordship. Now, my lord, kindly come to this act of Joseph.
Yeah.
Section 10, kindly see the section 10. Education regulation.
Section
10 of the Act. Education subject to the provision of the Central Council may subject approval of the regulations.
we have a regulation.
My lord, I am coming to the regulation. All right. This is not.
Where is the act?
Acta dao, Joseph. Acta dao.
Act is, there is another paper. No. No, the act is not there.
Joseph একটা act দাও আবার বলছো তুমি বড্ড বাজে কথা বলো যা যা একটা কপি তাই দাও তুমি একটা দেখাচ্ছি act তুমি একটা দাও
You have given us a regulation, madam. You have not given us the act.
Pharmacy Act.
Referring a parent act.
পড়েনি আমি আটকে গেছি অত দেরিতে বসলে আমি কি করবো আমি তো অতক্ষণ ধরে বসেছিলাম আরম্ভ করে দিয়েছে লেটার কাম at 115 I will mention the matter. অদ্ভুত কথাবার্তা তোমাদের তো ইয়ে থেকে দাও বার করো Anyway, Milord, in the meantime, Milord, I just one section I am reading, Milord, section 16. Kindly just bear me, Milord. Kindly excuse me. I am giving it. Section 16 of the Act. The Executive Committee means
Of the-
executive.
The Pharmacy Council of India.
The Executive Committee may appoint such number of inspectors as it may deem requisite for the purpose of this chapter, and inspector may inspect any institution which provides an approved course of study, attend at any approved examination, inspect an institution whose authorities have applied for the approval of its course of study exam, so and so, an inspector attending at any. What I am submitting, Section 16 speaks about that. The inspectors appointed by the Pharmaceutical Council of India only can inspect, not the university's persons.
When that act came into force.
Pardon?
when This act was enacted.
This act is
1948.
1948. Long back. Now I am coming. I am just you kindly excuse me. The act I. কি করো তোমরা না? I'm not kindly see this Pharmaceutical Council regulation which has been given to you, lords.
Yes.
See, these regulations may be called the master so and so, qualification as for so and so. That's my lord, kindly come to approval of postgraduate pharmacy. They kindly see the regulation scheme for approval postgraduate pharmacy causes course and examination, how it will be done, which has been done. Eligibility for conducting postgraduate course. The institution, kindly see 4.2. The institutions approved by the Pharmacy Council of running Bachelor of Pharmacy course under Section 12 or institute established by the central government, state government for the purpose of impairing for education shall be eligible for starting and postgraduate degree course. After the sanction has been given by the PCI, then no one can say, no, I will not, you will not, I will not allow you. Inspection, if it is required, would be done by the PCI, appointed by their inspectors. আমি কিন্তু বইটা চাই আমার যশোকে দিতে হবে. Now kindly see the role of the university. See, my lord. Appendix B of that. The examining authority shall be an Indian university constituted by the central government, state government, union territory administration for deemed to be university. It shall ensure that discipline and decorum of the examination are strictly observed at the examination center. What is their power to inspect? It shall permit the inspector of school, the pharmacist to visit and inspect the examination. It shall provide adequate rooms with necessary for so and similar. These are the requirements. What I want to make a submission and I want to build up a point before your lordship is this.
Yes.
After approval of the PCI, the effort has been made by them to inspect, non-adequate steps. Nothing has been done. Inviting the court, send the team for inspection. This is thoroughly beyond the scope of the act and regulations. He is nobody to do it.
Yes.
Now, my lord, kindly see, my learned friend, madam, on the other day has submitted before lordships, all have been closed long back, October. Course has been started, semester that has said to your lordships. I will come, my lord. See, their college, university college. Kindly come to me, lord. Page 622. জাজমেন্টের কপিটা আছে তো? Maulana Abul Kalam Azad University of Technology, West Bengal, that is their students. So far their students are concerned, notice is 13 November 2024. Merit list has been issued. Submitted then first semester June, second semester January, then how? We know winter semester and এটা কি বলেছিল?
Autumn semester, winter or spring,
Winter and spring.
autumn.
Now see, my lord, this is their 13 November 2024. They have issued their merit list. Last merit list. Now, my lord, kindly come to me, lord. Judgment আমি পড়ে আসছি। Semester, they were telling about semester. Joseph, বইটা This is the semester of the university. See, chapter 2, 1. Each year shall be divided into 2 semesters. Autumn semester, July to December. Therefore, July to December had gone because you, in your college, 13 November 2025, you have issued the merit list. Then the January comes. On the other day said, July to December and spring semester, January to June. The autumn semester shall ordinarily begin in July for students already on rolls. And the spring semester shall ordinarily begin in January. However, the first semester, order for newly admitted may begin a little later depending on completion of admission formalities, the number of teaching weeks, with the new 19. So this is the semesters. Which semesters you are following? You are applying in our case, and in your case, what you have applied? So for the college, university's own college is concerned something new, something will be allowed. But so far
They are running their own institutes.
They are having similar. They are having their colleges, own college, and other colleges
Affiliated to.
affiliated. Now, my lord, the number of teaching week in each semester shall be 15 to 18 with a minimum of 90 teaching days, excluding the period of examination. This is, my lord. Then, my lord, kindly see 2.3, next page.
Should close.
Admission shall ordinarily close after a specified period from the date of commencement of the first semester in instruction through a notification. However, in exception, admission of a candidate after the last May be recommended to the university with a justification by institution college. Under such an event, that period shall not fall beyond 4 weeks from the date of commencement of the first semester instruction. Therefore, this is the act where we are working. This is the regulations where we are working. One, we have to work. Seeking for an inspection. Not kindly see from the very beginning they are stalling. I don't know what is a grudge against us. But one judgment just I will show to your lordships. Then
maybe you are having a larger number of students than their own college.
Maybe
that you are hitting larger number of the students.
No, I don't have the scope.
Then in comparison to their own college.
No, I don't have the scope. That is all PCIs.
You could not get it what I'm saying.
I understand. Yes. I understand. Other things I can't say. Please.
প্রথম ইন্সপেকশনের এখানে রেকমেন্ডেশন রিনিউয়াল অ্যাপ্লিকেশন হিয়ার বি রেকমেন্ডেড
কোথায় পাবো?
পেজ 56 এটা ফার্স্ট
এখন আবার নতুন করে আমি কাগজ দেখাবো আবার তুমি আমার বের করছো। Madam, kindly see this judgment. The Pharmacy Council of India versus Dr. S.K. Tosniwal Education Trust. This is reported, although, but I have brought this. Reported. Now, তাহলে একটা copy now. Reported আছে।
You know, neutral citation number.
Citation number is not there.
Neutral citation number.
কি আছে দেখ।
Now the apex court has introduced a neutral citation number.
I am not aware about this.
No, you will find it as a
Find it.
Yes.
Kindly, Millard. Come to the paragraph 12 of the judgment, paragraph 12.1, 12 and 12.1. But 12, while answering the issues of question involved in the present batch of petition, first of all, which is required to be considered is whether the Pharmacy Act, which is a prior act to that of the AICT Act, can be said to be a special act with special promises in the field of pharmacy. This statement of objects, then 12.1. But there is comparing with the two central acts even.
That is what I was just trying to understand at that point of time, because this act appears to be an act of 1948.
Yes.
It's a prior act.
Ah.
And there is a subsequent act, I think the UGC
AITC Act.
Or here it comes as AICTE.
AICTE.
On India, I think
it's central. It's a general act.
So they have come. So once they are pitted against each other, then which should
that is answered. PCI will apply. That has been answered. Pharmaceutical Council of India Act will apply.
Yes.
That's the reason I am. Paragraph 12. Then paragraph.
What is the question? Whether the mandate of PCI or that of AICT
ACT can be said to be a special act.
Would prevail on the question of granting approval.
Correct.
And related matters to any institution for conducting pharmacy education course. Then say if there is any conflict or contradiction in the opinion of these two bodies, the issue is as to which body, that is AICTE or PCI, would primarily be responsible for regulation of the pharmaceutical regulation in India. Because I find 1948 Act, but this regulation was out of 2014 or 17.
Regulation is framed under the Act itself.
That is, I know, section 10 and 12 of 48 Act. But why after such a long time the regulation was framed?
But maybe below other regulations were there.
Regulation.
Yes, maybe earlier these regulations.
I was inquiring about it. That I
will.
But I do not find any repeal clause in the regulation. Normally, if the earlier regulation is superseded or repealed, there is a repealing clause that this regulation is hereby repealed. But I do not find any repealing clause here. So probably we have to take it that it was framed, regulation was framed for the first time in 2014.
2014. And all that's Lordship is aware about that legal principles, any sub-delegated they part of the Act itself.
No doubt.
But then kindly come to 12.1. As per the preamble of the Preemption Act, the Pharmacy Act has been enacted to make better provisions. 12.1.
I do not find 12.1.
12 and 12.1. 12 I read it.
No, there is only 12. There is no 12.1.
It is there. It is there in the reported version.
No.
এখানে নেই। এখানটা নেই। 12.1 is there in the reported version.
Starting with what?
It is 2021 10 SCC 657. Starting with as per preamble, as per the preamble. Sorry,
2021, can you repeat the
10,
section?
10 SCC,
2021,
10 SCC,
10 SCC,
657.
57.
Paragraph our consideration. It is under the head our consideration. And there is 12.1, as rightly pointed out by Mr.
12.1 starts.
Yes, it starts with as per the preamble of the Pharmacy Act.
Oh.
It is 30.
If you come to page 27 of this judgment which he had,
27, 27.
please come to page 27.
That's right.
No, I am
You will
reading
not
from
find-
SCC.
You will
No,
find
no,
it
no,
under
no, it's not there.
paragraph 13.
Correct. It is not there.
Ah.
Right. Let me read this.
Paragraph 13.
Yes, yes. As per the preamble of the Pharmacy Act, the Pharmacy Act has been enacted to make better provision for the regulation of the professional and practice of pharmacy, and for that purpose to constitute Pharmacy Council. Just 1 minute, my lord. Why you have brought this one? Why you have not brought the SCC? This is recorded here in the SCC.
Supreme Court's website থেকে down.
যখন আমি দেখাচ্ছি সুপ্রিম কোর্ট এসসি থেকে জাজমেন্ট, তখন ডাউনলোড থেকে দেখা করবে।
2021
অদ্ভুত তোমার ব্যাপার একদম। তোমার মতো করে সবাই চলবে নাকি? I am reading from 2021.
No, read it. We can collate. We can collate. Don't. Yes. If we
As
consider.
the President Act has been enacted to answer. If we consider the relevant provisional fund, it covers all areas, inclusive approval of course, laying down course, content eligibility, conditions for students as well as teachers, evolution of standards of examination, grant of registration, enter of the taking sanction for any infamous conduct, etc. The relevant for so. Then, my lord, I am just skipping 13.1 next paragraph, section 10.1, 13.1 of your lordships. Section 10 of the Pharmacy empowers the PCI to frame education regulation, prescribe the minimum standard of education required for qualification,
Pharmacist.
Yes, pharmacist. As per subsection 2 of section 2, such education regulation may prescribe. Then as per what I ultimately want to go, this is a long paragraph is there. This is 16, paragraph 16. Compare করে ये बोले দাও না গো।
16 টা কি দিয়ে শুরু হচ্ছে?
The aforesaid question is also required to be viewed. That is এই জন্য কিছু তোমার গাড়ি থেকে নামিয়ে দিচ্ছে, ঠিক করেছিল। The aforesaid question is also yes, paragraph 17.
Para 17.
Para 17, page 41. The aforesaid question is also required to be viewed from another angle. Both PCI and AICTI are the creature of this statute. Therefore, it is not all healthy that the two regulations, both being central authorities, can be permitted to fight for supremacy. The fight of supremacy between both the regulations is unhealthy for the education sector as well as the institution to permit two regulations to function in the same field. Therefore, also and more particular, when PCI is consisting of the experts in the field of pharmacy and other related subjects, it is the larger interest in the field of pharmacy that PCI must be given the power to regulate in all the pharmacy. Then, my lord, paragraph in view of the above.
Yes.
Paragraph 21. In view of the above, and for the reasons stated above, it is held that in the field of pharmacy education, and more particular so far as the recognition of degrees and diplomas of pharmacy education is concerned, the Pharmacy Act 1948 shall prevail. The norms and regulations set by PCI and other specified authorities under the Pharmacy Act would have to be followed by the institution concerned imparting education for degree and diploma in pharmacy, including the norms and regulations with respect to the increase and or decrease intake capacity of the students, and the decisions of the PCI shall only be followed by the institution imparting degree and diploma in pharmacy. The question are answered accordingly. Now, therefore, my lord, I will conclude my submission with this, my lord. By making any attempt by the university, by taking recourse of any by the university, my approval for 2024-25 given by the PCI cannot be nullified by them. They are trying to nullify this.
You could cite this judgment before the single bench.
Single bench, only inspection. You
cited that why you wanted on the diktat of the university. These directions were passed.
Lord, I am very honest to your lordship and candid, I must say. No, the argument which I am making, the legal point, that has not been argued. I am very honest.
Yes.
I should be very honest. Now, here, see, they don't have any regulation to relate to pharmacy. Not like the Central AICTE Act. And whenever I say AICTE, immediately it comes AITC. Sometimes I commit wrong. Anyway, AICTE. Therefore, here is only the university has to follow. University own regulations, statutes, so far this semester is concerned. Semester has not been said in the Pharmacy Act. Speaking about the affiliation, I will not give you affiliation. What do you mean by affiliation? Under what provisions of law it has been sanctioned, written? I will not allow you.
According to you, they are the examining authorities. They are only supposed to conduct the examinations, evaluate the answer scripts, and then publish. Because your regulation also says that it was an examining body who will be there. But all the other regulatory paraphernalias are to be monitored, guided, and regulated by the PCI.
Correct, madam. Now, I am concluded. What is my prayer here at this time? This is an interlocutory stage we are here. Therefore, I am praying to your lordships, kindly allow to take our classes. Then your lordship
admitted. You have not admitted.
And not to, and I should be allowed to be admitted.
Yes.
Yeah, I should be allowed to be admitted. Yes, and thereafter, yeah, I should be allowed to be admitted. Then your lordship either hear the appeal or hear the writ petition, whatever it may be, finally it should be decided. What is the, I do not know what sadistic pleasure they are enjoying in there.
PCI is a party here.
My lord, I am appearing for the PCI.
Mr. Theory is appearing, I don't know.
My lord, I am appearing for the PCI in this matter, my lord.
PCI was not included as a
Correct,
party
you are right.
in the
Here we have it added here.
How?
In the appeal, we have a filed an
My
application.
lord, I am appearing for the PCI in this matter.
Application, you have
no difficulty.
So what?
There is no difficulty.
Mr. Theory is there.
My lord, I am appearing for the PCI, my lord. I have very limited role in this matter. I have prepared a...
Sir, you have the most important role and you say the limited role.
My lord, I have prepared a process how we give the permission. My junior is there. My junior is handing over the process as simple 2 pages note, my lord. My lord, what happens at the very first stage, any college authority, they apply before the PCI for getting permission in the PCI portal. They call DG Pharmed. Subsequently, after payment of the charges, the PCI reviews the application. And the second step is PCI reviews the application for the competence and other statutory guidelines. Then land and building ownership documents, faculty appointment letters, consent for examining authority as a state, and NOC from the state government. That is more important, my lord. NOC from the state government. If the state doesn't give the NOC, they will not be able to operate, my lord. They will not be able to apply even.
Yes.
Subsequently, fire safety and other instruction. And next step, PCI conduct one inspection, physical or online.
So according to you, only after the state government issued NOC,
yes, my lord,
not go for a step 3.
Yes, my lord. Because at the time of application in step 2, they have to give the NOC document even.
Yes.
Subsequently, after completion of the process, after step 3, physical or online inspection, they investigate, they prepare a report, and if any compliance is required, suppose there are any problem or any lacuna, then PCI intimates the college, and if the college will rectify that, after rectifying that, they will again approach the PCI, and after reviewing the compliance report, after they will taking decision, they grant the permission. This is the procedure, and there is a revocation procedure even. If the state withdraw the NOC and other things are there, then the permission given by the authority can be revoked. But here in this case, from the documents I have understood, this authority has given NOC. From the after getting the NOC, the college, this particular appellant before your lordship, approach the authority. After conducting inspection and after checking all the things, after getting all the things tick marked, the PCI has granted them the permission. PCI is the parent authority of pharmacy education. After going through the document, after going through the process, and after going through the papers, they grant permission. Your lordship will know, my lord, from 2019 to 2024-22, there was a moratorium. In state of West Bengal, PCI was not giving any permission to any pharmacy college. Subsequently, that moratorium was withdrawn, and the notification, my learned senior friend already shown, the notification was issued. PCI was keen for the pharmacy education, and for the particular thing, they have granted the permission. Now it's a fight between state authority and the petition. I don't know what is the reason, because they have given the NOC.
Yes.
That is my humble point, man. After getting at that one point, they have given NOC, and till date the NOC has not been withdrawn. PCI is the parent body, and unnecessary as conflict is being drawn.
No, I got your point. It's
That's
again
all.
the same. It is against the same observation which the apex court in that judgment says this is really a usurpation of a power of supremacy. Anyhow, let us consider. Yes, thank you. Where is the university?
Yes.
Are you supreme or the PCI is supreme? That's the question.
Obviously, PCI is supreme. And I proceed on the basis that PCI is supreme. When there is a law which has been laid down by the Honorable Supreme Court, it is not gainsaid that PCI is not supreme. And applying the age-old principle of general area, especially was non-derogant.
Even the reverse is.
Especially a generally was derogant. There are two. So, may I just take?
Both are applied. Tailored with the situation.
So, I take your lordship to. We'll kindly take this list of dates what we have prepared. It Josh had the din. I'm soft koi party. Well, I will not take much of your lordship's time. Well, kindly take page.
We appreciate that.
Well, kindly take, my lord, page 52 of the stay application. Page 52.
Yes, sir.
My lord will kindly take, my lord, this no objection certificate which was given by the university.
True.
May I just read it out? These two certify that we have no objection for introduction of new course, namely M.Pharm Pharmaceutics.
We are concerned with that.
Yes. There are 3 courses, my lord. M.Pharm Pharmaceutical Chemistry, M.Pharm Pharmacology of Gitanjali College of Pharmacology, Gitanjali College of Pharmacy, so and so, affiliated to Maulana Abul Kalam Azad University of Technology. It is affiliated in the sense, my lord, it is already affiliated for the B.Pharm courses.
Whatever.
West Bengal, as proposed by the management of the college. This next portion is very relevant. subject to the fulfillment of the statutory formalities and other conditions as laid down by the different approving authorities, it is made clear that for the purpose of affiliation of this university, the organizing, sponsoring trust management of the college is required to fulfill the affiliation requirements of the university. Then, liabilities, if any, on this count, this is not relevant, but we will come to that. Taking cue from the submissions made by Mr. Tiwari, who is appearing online for the Pharmacy Council. So, these documents, like the NOC from the state, NOC from the university, are submitted along with the application for getting approval from the Pharmacy Council of India. This NOC is again, is a conditional NOC, as would be evident from the NOC itself. Now, having regard to that, inspections were carried out. I make it clear, subject to correction by Mr. Bandyopadhyay, all the orders passed by the Honorable Single Judge directing, allowing or directing this university to carry out inspection are not under challenge in this appeal.
No, that he admitted.
A.
He was very candid when I asked whether this judgment of the Supreme Court was cited
Yes.
before the single bench. He candidly said
Right.
it was not. But all these orders came to be passed.
Yes.
Anyhow, but the law is a law.
Law is a law.
has to be respected.
Law is a law. Law has to be respected. Now, the next question is that not even challenge, and there is no ground in the memorandum of appeal. I will stand corrected, challenging the authority of the university to carry out inspection.
Order 41, Rule 1, and then the subsequent one, he can take any point which is not taken.
Not in the memorandum.
The leave of the court, if the leave is granted, only thing is that you cannot be put to a surprise.
Absolutely.
Only to make you aware that this is the point or a.
So, my lord, I will be now, my task is now much more lessened. In the sense, the compilation, our compilation. Flag করা গেল না না kindly give one হ্যাঁ এনেছি জানি এই জন্য তোমাকে এত ভালোবাসি
He taught me this. He said, if you don't know this system, you don't have any authority to carry iPad in High Court.
No, right.
Yeah, one day he threatened me. And all right, I have said, I have become old. Old on you. Why you are iPad you are having? Then two persons are, he is first set, and two persons are very, who has great role to learn all these things. One is Chief Justice, ex-Chief Justice of India, Justice Chandrachud. Another one is our Honorable Speaker. Here everything is my all reports, etc.
He wanted the paper.
Now
I am always in.
Now, I tell you,
having a paperless.
I tell you, Lord, in the Parliament, I am only one person. Or in the standing committees meeting, etc. Only one person carrying and doing everything. Carrying and doing everything, and because I learned it because of his threatening, I must say. Now, after seeing this, the Honorable Speaker called me. Then said, I will give.
One more.
I will, you
NOC which was issued by the university, and this is the procedure. Because every year, for every year,
What you say is
yes,
that under the PCI
yes,
Act,
yes,
it is the PCI which is a main body.
absolutely, absolutely, yes,
Has a right to inspect, who has
right,
a right to see that everything is in order,
right.
and thereafter he can grant an approval.
Similarly with NCT,
Now,
similarly with NCT,
that is what I'm saying.
yes,
Now you say that you are a university
yes,
guided and regulated by your own general or central act.
yes,
Let us
yes,
go by that.
yes, 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 yes,
You have certain set norms for an affiliation. I understand
right,
where you are heading.
right.
One is for granting approval,
And another is for
one is for affiliation.
affiliation.
Continuing with the affiliation.
Yes,
or
yes,
for
yes, yes, yes.
Understand where you are heading. But the problem is after this judgment,
Yes,
if for affiliation
yes,
and for approval, if it appears that there is a common
right,
platform,
right,
that what are the requirements, and if there is any conflict
right,
in this two,
right,
then what would be the role
yes,
for the affiliated college? What you will do? Suppose let us take very extreme example,
right.
irrespective of irrespective of
Yes. Kindly take, my lord, paragraph 3. My lord, this is the third inspection report. Paragraph 3. Right, 127 of stay. As per PCI norms, 4, my lord has got that, my lords? My lords have got that? Yes, I'm sorry, my lord. As per PCI norms, 4 professors, 7 associate professors, 20 assistant professors are required for the above mentioned programs. 4 professors and 5 associate professors and 25 assistant professors were present during inspection. 10 new faculty members, associate professor 4, assistant professor 6 joined in October and November 2024. These faculty members were recruited violating the UGC regulations. No recruitment advertisements were published in the leading newspaper for recruitment of assistant professors. No outside subject experts were present in the selection committee. University nominees were also not present in the selection committee. It can also be noted that the selection panel provided to the inspection team showed only 4 faculty names, and out of these 10 new recruited faculty members, and no selection panel was provided to the inspection team for the rest of the newly 6 recruited assistant professors. Kindly now take their exception. I will take your lordship directly to the relevant paragraph at page 134, 135. Oh, the quote করেছিস আমাদেরটা. It starts at page Miss Shaw is correct, Miss Shaw, but relevant portion their response is at 135. The first new paragraph at 135. All the recruitments to the post of faculty member to the petitioner college has been conducted in compliance of the relevant rules and regulations. The allegation of non-publication of advertisement and absence of nominee of the university is false and fabricated. In this regard, it is pertinent to mention here that the petitioner college published advertisement in 2 leading newspapers, Ananda Bazar and Statesman, inviting applications for intending candidates for the post of faculty member. On repeated occasions, either through email or through hard copy letter, the university was requested to provide expert and or nominee from the side of the university to conduct interview for the appointment of vacant posts. However, the university chose not to send any nominee. Photocopy of the relevant documents are annexed herewith and marked as Annexure D. My lord, kindly take Annexure D, which starts at page 208. But this is the letter they refer the request for, my lord, the appointment of university nominee, addressed to one particular professor, Dr. C.M. Hossain, not addressed to the university. 208. সব দেখাবো. So, this is not addressed to the university, as your lordship will find from that. This is 5th October 2024. And the advertisement your lordship will find at page 209. Kindly take, my lord, what is the application invited for the post of professor and associate professor in the Department of Pharmaceutics, Pharmacology and Pharmaceutical Chemistry. Now, my lord, kindly take the circular. This is relevant. This is the constitution of the selection committee. 211. Kindly take, my lord, who are the members of the selection committee? All the, my lord, professors or faculty members of the this college, this institution. Then, my lord, kindly take, this is where the things get little interesting. Kindly take, my lord, the appointees, the list of appointees. First, my lord, kindly take Ashit Ranjan Shahu. He has been appointed as associate professor, as would be evident from, my lord, page 220. So, my lord, in the case of appointment of associate professors, advertisement was issued, but my lord, no university nominee was member of the selection committee. Then, my lord, kindly take 3 Dr. Sonali Roy, again associate professor. This is page 227. Then, my lord, kindly take S.S. Bhattacharya, 213, associate professor. And lastly, my lord, kindly take Dr. Shakti Jeet Das, 233, again associate professor. Now, my lord, now kindly take the list of the these assistant professors who have been appointed as assistant professors who have been appointed in this particular institution. First is Nirupam Mondol. Sorry, my lord, kindly take first 247. Roshi will kindly take the date of appointment 247. Admittedly, no advertisement issued, no interview board constituted. Because, my lord, they say, kindly take the letter. They say, I am pleased to inform you that based on your academic qualification performance, the interview held on 28 September 2024. My lord, if 28 September is the date of interview, this particular, my lord, interview selection panel or the selection board was constituted only for the purpose of interviews to be held on 1st of October. Kindly take the circular along with this. Kindly take the circular at 211. The circular is dated 28th of October and for interview to be held on, 30th October. I'm so sorry. So, my lord, for the appointments made to the post of assistant professors, there was practically no interview board, as would be evident from their records. It is their exception affidavit, not my document. My lord, I will give one by one all the details. All appointed on 28th of September. Next is Sudeshna Das, because they were all appointed prior to the constitution of the selection committee, prior to the issuance of advertisement for the post of associate professor. 254. This is all part of Annexure D, where they say on oath that they have complied with all the necessary formalities. Assistant professor, my lord has got that. My lord, kindly mark the date of interview, 28 September. Then, my lord, Shayoni Debnath. This is 261. This is 261. Again, my lord, the date of interview is 28 September. Assistant professor. Lastly, my lord, Disha Das. Date of interview, 28 September. Admittedly, no request was put in for the interview to be held on 28th of September. And I will place the UGC regulations and I will conclude. Kindly, my lord, now take, along with this, page 275. Ankona Rai. And the interview held on 28 October. The date when the circular was issued for appointment of selection committee for the interview to be held on 30th of October. So, all the appointees to the post of assistant professor were made, or where these appointments were made in contravention of the circular issued by PCI read with the UGC regulations. Each one of them. The university as an affiliating body cannot shut its eye. Cannot. Now, along with this, kindly take the UGC regulations for once. এটা কি জজ সাহেবদের কপি? না এইটা দিয়ে দেওয়া হয়েছে? না এটা দেওয়া হয়নি? এটা দেওয়া হয়েছে? এটা দিলে এত কপি করে দেখো মানে I believe we have not handed up this one না না এটা দেওয়া নেই এটা এত মোটা এটা তো রয়ে গেল ঠিক আছে কোনো ব্যাপার kindly take my lord kindly take my lord the UGC regulations because it is 2010 as amended. Well, the last amendment was made in 2018 subject to correction. Now draft regulations have been published in 2025 which are yet to be approved. Well, before I take your lordship to kindly take paragraph or regulation 3.1.0 এক্ষুনি দিচ্ছি পড়ে দিচ্ছি একটাই পড়ে মানে kindly take 3.1.0 এইটা আমার পেয়ে গেছি মিস্টার বন্দ্যোপাধ্যায়
You should not carry a single paper in court. Everything would be there. Why you are
মানে kindly take 3.1 this is UGC regulations the direct recruitment to the posts of assistant professor associate professor and professor in the universities and colleges and senior professor in the university shall be on the basis of merit through an all India advertisement followed by selection of a duly constituted selection committee as per the provisions made under these regulations. These provisions shall be incorporated in the statute or ordinances of the university concerned. The composition of such a committee shall be specified in these regulations. Now, along with this, regulation number কত ওটা 6 point কত বলো page 3.1 প্রথমে 3.1 করলেন page 70 58 করলেন দা এ প্রথমে সেকেন্ড পাতা এইটা না
circular?
না না এটা না এটা এর কপি বেটার Now, Miller, kindly take this is assistant professor
5.1 Roman 2.
Now, Miller, this is assistant professor. Kindly take this. This is 5.
5.1 Roman 2.
Roman 2. 5 assistant professor in colleges, including private and.
You are concerned with associate professor.
No, for assistant also, because for assistant there was no committee at all.
Selection committee shall consist of the following: the vice chancellor or his nominee.
The vice chancellor, no, my lord, your lordship is reading page.
You are taking us to assistant professor.
Yes, assistant page 71.
Yes, obviously.
5.
Page 70.
No, my lord, that is university for the appointment in university. I am taking your lordship to 5 assistant professor in colleges, including private and constituent colleges. Your lordship will find the selection committee for the post of assistant professor in colleges, including private and constituent colleges, shall consist of the following persons: principal, head of the 2 nominees of the vice chancellor of the university. For associate professor, Roman 6, again, my lord, similar. Similar provision. So these regulations stood violated for appointing these associate professors for whom advertisement was issued, and for in the case of assistant professors, even no advertisement was issued. So today, if the relief which Mr. Bandyopadhyay's client is seeking before your lordship, the relief is like this, my lord, that there is no definite timeline for running a semester or administering a semester course. If I had added to that timeline, my lord, no admissions could have been made in the month of November. If I correctly understood Mr. Bandyopadhyay.
after November?
However, December, whatever it may be, December. So, my lord, in this case, well, there is a concept of odd and even. or first and second. Let us talk about first and second. First, second, third, fourth, fifth, sixth. Well, first semester examinations are over on 18th of January. The impugned order was passed on 13th of January. Now, my lord, the second semester, the courses are on. It is the case of Mr. Bandyopadhyay, admissions are yet to be made, subject to correction again. If admissions have been made, they could not have admitted students because they do not have affiliation. My lord, then, my lord, it would result in a complete overhauling of these regulations, what we have. Complete overhauling of these regulations. Complete departure from the regulations which we have. This is, my lord, then we have to make a bespoke or a tailor-made course for this particular institute.
What is the sanctity of this process handbook?
My lord, ask them, ask the Pharmacy Council.
What is the sanctity?
The sanctity is,
We have an executive.
well, it is a body of instructions. My lordships have taught us. My lord, may I?
Very clever,
Yes.
which invites a legally enforceable right.
My lord will kindly take the right.
Held by an executive body or a committee of the SDI
Yes.
adopt something.
Yes.
It is not contemplated either in the regulation or in the act itself.
My lord, kindly take the first. My lord,
Following a provision of particular act
yes.
or a regulation.
Yes.
I think it is a legislative process. There are two ways of another act to be brought within the purview of one act.
Right.
Either by way of a reference
or incorporation.
Incorporation.
We all know that, my lord. That is well settled.
Reminded.
Yes.
Whether an executive committee of
my lord,
PCI has the power to incorporate.
Then, my lord, the circular, then the validity of the circular is to be challenged in independent proceedings.
The circular, which per se is not in accordance with law. Just I am saying it's a void document.
My lord, may I just answer to your lordship's query? It is my duty to answer. If the regulations framed by PCI leave certain fields, leave certain gaps, and if the gap filling exercise,
that gap filling has to be done in what manner?
Gap filling exercise can be done, my lord.
There must be an eminent power in this regard.
Let me put it in this way. What do the regulations say? First, an advertisement. It is no longer res integra that for appointment to any public post or any appointment which has some kind of public flavor, my lord, advertisement is mandatory, whether there is any regulation or not. For appointment of a faculty member, such an important post, my lord, faculty member, my lord,
So you are heading towards the Visheshwar Rao's judgment.
Yes, KVN Visheshwar Rao.
That is what I am thinking. You are keeping that in mind.
Yes.
And say wide publications. They say it is not that there was no publication. There was a wide publication. Only thing is the constitution of the selection committee.
No, my lord, for assistant professor, there was no publication. For assistant professor, there is no publication because assistant professors were appointed prior to publication. No, prior. Publication মানে হচ্ছে newspaper. Assistant professor রয়েছে 28 সেপ্টেম্বর, 28 অক্টোবর.
27th September was the publication.
27th September was the publication. Newspaper date is there.
27th, yes, there. In the
But
if you come, I can.
But not for the post of assistant professor.
Normally do not.
My lord, no, my lord. Your lordship normally does that. My lord, this kindly, I'm sorry, my lord, kindly. I'm sorry, my lord.
I was also getting, confused with.
My lord, the assistant professors were appointed on the basis of an alleged interview held on 28 September.
I was getting.
And এটা কোথায় 130 ওই যে মানে অ্যাডভার্টাইজমেন্টটা কোথায় দেখি 134 না কত একটা বেশ এই তো অ্যাডভার্টাইজমেন্ট দাঁড়া আমি দেখছি কত ডেট এটা তোরাই তো বলতে পারবি এটা কত ডেট। I'm just coming. My lord, মানে আমার হয়ে গেছে কল্যাণ, 2-3 minutes or 5 minutes।
শেষ করছো না, আমার অন্য করে মামলা ধরবে।
আমারও তো ধরবে, ওই জন্যই তো
শেষ করছো না তো।
করছি তো।
You will find at least 211.
211 very well mannered.
What you say is, this was according
One
to
of the
assistant
matters-
professor, and a professor,
Yes,
but not assistant professor. That is what I said.
and my lord, kindly take the date of interview given in the circular.
After that.
My lord, I
27th
stand
September-
corrected. My lord, it is my fault.
27th September
My
was
lord,
the date of
My lord,
advertisement.
my lord,
28th September was the date of interview.
my lord, it is now,
Month is 28th October.
but it is now perhaps more than 20 years, my lord, we are facing your lordship. We know that where we will commit mistake and where we will get caught. So my lord, I am not here. When your lordship has pointed it out, the matter ends there. But I have demonstrated in my own humble way, my lord, this cannot be done. And at this stage, at this stage. But these are my most respectful submissions, my lord, because my lord, this will result in absolute chaos. Today Gitanjali will come, tomorrow somebody else will come, that we have also done this, we have also done that. And there is an abject aberration. Abject aberration. But these are my respectful submissions, my lord. May I take your lordship's kindly?
Please, your lordships. Beg your lordship. My lord, yes, my lord, there are, my lord, the decree, my lord, was of 18th August 2010 in favor of my clients. My lord, much water has flowed under the bridge, my lord, which I'll have to, my lord, show your lordships. My lord, eviction decree.
The ground of
My lord, non-payment of rent.
only.
Yeah.
Not a lengthy argument, not a lengthy judgment.
No. Sorry to interrupt, my lord. The instant appeal arises from an order allowing an application under Order 21, Rule 98.
Oh, that is from the execution.
Correct.
FMA. Or SMA.
My lord, your lordships, my lord, had it, my
If it-
lord, wait, one.
From which
My lord, there was an order, my lord, passed by a
third party.
I am it.
For a third party. Decree set aside. The right title and interest is declared.
My lord, before my learned friend starts, my lord, I have one submission to make. I do not want to stall the proceeding. They have prepared, my lord, compilation of relevant documents or papers. My lord, that compilation of papers, my lord, for convenience, it's which we not.
Exhibited documents.
No.
That those cannot be relied upon. No division. That points out. So then they'll have to take out an application.
They have taken out an application under Order 41, Rule 27, but that documents, my lord, are completely different documents.
So those have to be heard along with the appeal.
Yes.
Yes, but there's an order to that effect. Yes.
Yes, you are a landlord.
Yes.
You are a landlord. You filed a suit for eviction against your tenant.
Yes.
On the ground of default. Ex parte decree or contested decree?
Contested decree.
Contested. It is under 56 Act or a 97 Act.
My lord, the suit, my lord, Transfer of Property Act.
Ground of default is a forfeiture of lease.
Yes.
The forfeiture of
Yes.
lease. 114 resorted to.
It's not Transfer of Property Act, it's 106. Yeah, my lord, 106 notice, my lord, it's not, my lord.
100 is a forfeiture, 106 notice.
Yes, my lord.
Or it is a simple determination or termination.
Determination, my lord, of the lease. Determination of the lease.
Determination of the lease.
Yes.
There are two because section 111.
I know. Yes.
One is a.
My lord, 15 days notice.
The period provided under section.
My lord, this is 15 days notice.
And second one is the notice of forfeiture. These is still continuing.
My lord, it's over, my lord, monthly tenancy.
Okay.
15 days. Correct.
So no ground of default is required.
No.
No ground
15, not required, my lord, 15 days notice.
Correct.
Yes.
Notice not challenged.
No, nothing, my lord.
Okay.
My lord, findings, my lord, on merits, appeal, sustained an appeal, review.
Right. What they claim. How?
My lord, they claim, my lord, that the decree that I have got is in respect of a property, my lord, where they were there and not the respondent number 2.
Okay. So they have the independent right title and interest.
Yes, my lord, they are, my lord.
He holds you.
Absolutely.
No, not yours, my lord. It has been held here, my lord, that I am the owner and they are my tenants.
The tenancy right is.
My lord, that's, my lord, now they have said, my lord, the order which they have obtained, there's a cross objection also. The order that they have obtained, my lord, says that, my lord, I am the owner of this property. My lord, I served notice on the wrong person.
Okay.
And, my lord, the wrong person was an occupation. That decree, my lord, was executed. And, my lord, appeal, revision, my lord, review, my lord, specially petition, my lord, not once. Supreme Court direction, second time saying, please execute quickly. And my lord, what happens, my lord, at the end of the day, my lord, this is the 6th attempt, my lord, I'll show, which proved successful.
That very celebrated observation of Sir Vivian Bose. The real trouble starts after
Yes,
the-
my lord. That's why your lordships had those, the rule committee, my lord, framing of, my lord, the rules regarding, my lord, money claims also.
My lord, there are exceptions to that also. And this is an exception.
My lord, I'll just show your lordships the facts. My lord, it'll, my lord, come back, my lord.
Then even a Supreme Court, a gentleman could not succeed before the Supreme Court also at the execution stage. Though his name suggests, but he could not.
Vijay.
Judgment is reported, the appellate there was before the Supreme Court, Sundar Prasad Singh. Men of such name do not succeed. Then who will?
My lord, when your lordships admitted the appeal, my lord, that's there, my lord. First paragraph.
Yes, that's all. That's all the record. So tell us that where is their application on the order 21 rule 97 read with section.
Yes.
201.
Yes.
Page 130. Sorry.
My lord,
There is-
my lord, kindly take, my lord, the convenience compilation. My lord, there are 3 volumes.
ঠিক আছে যখন দেখাবে তখন বলে দিতে হবে আর কি করবো
Where is it, Miss Case? Huh? My lord, kindly take volume 1.
The impediment of this bench to take up.
No, as I said, my lord, that the convenience compilation contains documents.
Just that. Just indicate which are the documents
I have prepared a list.
first time they wanted to rely upon. And then we'll take up that order 41 rule 27, whether they have included those documents there.
No, my learned friend's first submission is these are documents which are not there in order 41 rule 27. Let him, my lord, indicate.
No, there are 2 aspects. One is that these are the documents, they do not form part of the record in the executing court. First. Second is that these are some of the documents which are not included in order 41 rule 27.
Yes.
There are the
Two categories. My learned friend, my lord, gives that, my lord, list to me, my lord, I will.
We'll see to it.
Because we've been writing to them, my lord.
If you have included some document as an additional evidence, then there was no difficulty.
Correct.
And those who have not been included, then it's a separate issue.
Yes.
Yes. Where is their application?
My lord, convenience compilation, my lord.
Tell me from the paper book.
Hey,
Oh, no paper.
My lord, your lordships asked us to prepare a convenience compilation, my lord, page 134. Volume 1, my lord.
পেপার বইও তো রয়েছে ওখানে নেই
So it was supposed to be the compilation to include the papers which not only illegible but also the documents which have not been included there. That is what we want. Anyhow, give that.
My lord, page 134.
It আছে? Compilation we have. Tell us.
My lord, kindly take, my lord, page 134.
134,
my lord. Which item is it of the list? My lord, kindly take, my lord, the convenience my lord, there are 2, my lord. We were asked to refile, my lord, on the basis of an objection taken by them. My lord, that's volumes 1, 2, and 3, my lord. Wait,
No, I have got that.
No, there are 2, my lord, there are 2 sets.
Page number is telling. 134 I am looking at.
So that's okay.
Page 134 I am looking at.
My lord, your lordship wants me to place it, my lord. Very well. এটা দিয়েছেন ঠিক আছে।
My lord, may I, my lord? Lord, for your lordship's convenience, my lord, I have prepared a list of dates, my lord, which would, my lord, put, my lord, the picture, my lord. Because your lordship's permit, my lord, may I, my lord, just rely on that.
That I was not was that there was has come up with some was a person who took loan from him for that construction, and there was a clause in the agreement so long the entire amount is disbursed, the property would not be transferred to a third party. That was one. Second, saying that there was an agreement. By virtue whereof they were put into the position 12, 13th and 14th floor. Employees of this flat unit number 93. There was a terrace which was unconstructed or semi-constructed which they completed it. And now they wanted to say terrace flat number 93. They wanted to make a distinction. I do not know. Here from you, both of you, that what is that distinction that comes? Then he says that it was actually for a rental of rupees 500. Though for all the entire, the lease talks about 30,000 rupees, the rental in lease rent. They say that this name of this property got changed subsequently, and this was recognized by a sister of that group, and they accepted the rent. So the initial period of lease has expired, but they continued, and therefore they acquired the status of the monthly tenant. And therefore, filing a suit against a person who was never a tenant or the continuity could not be seen because you accepted me as a tenant. So this degree is not binding on that. If I correctly understood, in a very, I would say in a truncated manner, these are the stand which is taken. Why section 3 is quoted, I do not know. By the of 1997 to keep outside the body.
Well, that was the defense raised in the suit also.
Oh.
The defense raised in the suit also. Now, my lord, Raghuraj Puri, my lord, had an agreement to lease, my lord, on 1st September 1980, which your lordship would have seen, my lord, in their application itself. My lord, of, my lord, the suit property, my lord, which was, my lord, 3 floors, 12th, 13th and 14th. Floor, my lord, flat number 93. Also known as terrace flat number 93.
Anyhow, according to.
Yes. My lord, that's, my lord, our case. That was the evidence also which had been put in. My lord, one had a rental of, my lord, 13,000. Another had a rental of, my lord, 500 rupees. My lord, this agreement to lease, my lord, which was, my lord, signed, my lord, by Raghuraj Puri, was, my lord, with the respondent number 1. My lord, who is the applicant?
Indo-Arya.
My lord, both, my lord, they're all Aryas. My lord, I want to show your lordship what is happening. They're all Aryas, directors, partners, company units, all the same. That's what I want to show your lordship. Now they've come, my lord, after having failed. Not only lifting, my lord, they were never there. This is a new story now, my lord, in the 6th attempt. That's why I wanted to place, my lord, the list of dates. Now, my lord, kindly, my lord, 1st September 1980, my lord, is this, my lord, agreement for lease. No dispute, my lord, about this.
Just let me.
My lord, tin walled, my lord, this is, my lord.
Because I have not seen your plate. That's why I'm asking.
Yes. Now, my lord, may I?
Very cryptic.
Yes, my lord.
Involved and.
My lord, may I explain, my lord? My lord, Tevali Court, my lord, my lord, building on Gurushoda Road, my lord, that property, my lord, belonged to, my lord, the what? Mulliks, my lord, their trust. My lord, they granted a long-term lease, my lord, in favor of tin-walled properties to, my lord, build, my lord, construct, my lord, the flats, the multi-story, those days, my lord, multi-storied building, with, my lord, the right to sublease. My lord, one of the partners, my lord, of tin-walled properties, my lord, was, my lord, Puri. Wait 1 minute. Was, my lord, Puri. Now, my lord, there was a dissolution, my lord, of tin-walled. where, my lord, allotments were made, my lord, under the dissolution. Amongst the partners, Puri got, my lord,
12, 13 and 14.
my lord, and my lord, others. My lord, we are concerned with 12, 13 and 14. And my lord, what they have now brought up, my lord, as terrace flat 93, which is on the 13th floor, just a terrace to build on. This is, my lord, how, my lord, Puris came into the picture.
So Puri came, he was allotted this 12th, 13th and 14th floor. Then
Yes.
what happened?
Now, my lord, Puris, my lord, entered into an agreement of lease. My lord, there are two of them. My lord, one is 1st September 1980, my lord, which relates to 12th, 13th, 14th floor. For, my lord, a rental of, my lord, 6,500 to start with. My lord, this is, my lord, in 1980, 1st of September 1980.
For a period of 10 years.
For a period of 10 years.
Renewable.
Yes, my lord, it had, my lord, all kinds of clauses. My lord, I don't remember, my lord, a renewal clause. But, my lord, it was for a period of 10 years. It had a power, my lord, given, my lord, to the lessee, to, my lord, sublet. My lord, this was, my lord, the, my lord. And, my lord, the schedule, my lord, in the agreement for lease, my lord, is 12th, 13th and 14th floor of Block B, Tivoli Court. Now, my lord, on, my lord, 1st of June 1982, my lord, that was another, my lord, allotment made in favor of the Puris. My lord, of, my lord.
First was 1980.
My lord, first agreement is 1980. My lord, Puris had been allotted, my lord, different portions, my lord. Of second agreement related to, my lord, my lord, terrace. My lord, again for, my lord, a period of, my lord, 10 years on as is where is basis. And, my lord, the area. Yes, with a power to, my lord, for them to, my lord, construct. And, my lord, it was, my lord, for 500 rupees per month. And the total area, my lord, was 1,000 square feet. And it was, my lord, on the 13th floor. This is, my lord, of 1982. Now, my lord, from 1986 onwards, kindly mark, my lord, this date. My lord, what we say was the subject matter of our suit. My lord, 12th, 13th, 14th floor, flat 93. My lord, the rental was increased to 13,000 rupees per month. Now, my lord, then, my lord, Puri, my lord, gifted through a registered deed, my lord, flat numbers 12, 13 and 14 to, my lord, the plaintiffs. Who were the plaintiffs? His sister and his niece. Sister now has become, my lord, a super senior citizen, and my lord, niece is also, I think, a senior citizen. Through the course of this litigation. This is what he gifted through a registered deed of gift. My lord, my lord, area which was the subject matter of the lease of, my lord, 1st September 1980. My lord, we don't own, my lord, the terrace. We own only this by virtue of the deed of gift. We are, my lord, not owners, my lord, of, my lord, the terrace flat. My lord, we are the owners of 12th, 13th and 14th. Now, my lord, 14th August 1991, my lord, is when the deed of gift is, my lord, executed. 86 onwards, it's gone up to, my lord, 13,000. Now, my lord, in 1998, my lord, the respondent number 1, that's, my lord, the applicant under Order 21 Rule, my lord, 97, 98, 101. My lord said, my lord, that, my lord, they have transferred their leasehold rights in respect of the demise flat in favor of respondent number 2. Now, who is the respondent number 2? My lord, it's a partnership, my lord, which comprised of ex-directors of respondent number 1. Arias. Now, my lord, this document
my lord, has been accepted. That's, my lord, on the basis of, my lord, how 2 comes into the picture, because I filed my suit against 2 and 2 paid under this. Respond number 2, my lord, for 12, 13 and 14, my lord, it paid, my lord, the rental, my lord, to, my lord, my clients. So your lordship remembers, my lord, 1980, 1 was the tenant under Raghuraj Puri. Then, my lord, I have the deed of gift, my lord, from Raghuraj Puri. I become the owner of that flat. And, my lord, when I'm the owner, my lord, we get a communication, my lord, from 1 who is my tenant that I've assigned to 2, you please accept rent from 2. We accept that arrangement. We get, my lord, rent from 2.
He becomes an assignee too.
Correct. Yes. He, my lord, really, my lord, comes in, my lord, his place. Now, my lord, there is, my lord, default, my lord, in payment of rent by defendant number 2. 1 has never paid me rent, my lord, after that letter. And, my lord, their case, my lord, is they have paid rent, my lord, to Tinwald. Lordship might have seen, my lord, in the application. And the finding is correct. And the finding is there was, my lord, that's the finding against them. That, my lord, that story about payment of rent, my lord, for that premises, my lord, is disbelieved.
Was there any rent receipt issued by the Tinwald?
Beg your lordship.
Was there any rent receipt issued?
No, my lord. Nothing. My lord, is being disbelieved completely. It was dissolved.
Did they produce any rent receipt?
No.
Accepting the rent?
No.
For the verbal?
Yes.
Yes. Verbal
Yes, my lord, and they've shown some bank statements, etc. Yes. Now, my lord, the fact of the matter is, my lord, that they were, my lord, paying us rent. They defaulted. My lord, we gave, my lord, a notice. My lord, determining, my lord, the lease and asking, my lord, for, my lord, possession. My lord, that notice, my lord, was, my lord, they stopped paying, my lord, kindly note, from December 2003. My lord, once, my lord, they had, my lord, stopped paying, my lord, we issued, my lord, a notice, my lord, on, my lord, 14 September 2006. My lord, where we said, my lord, 13,000 rupees was the rental. You have not paid us. You please vacate. And, my lord, the notice, my lord, specifically refers to 12th, 13th, 14th floor, flat number 93 of Tivoli Court. I don't own anything else, my lord, which is tenanted there. I could only have. My lord, naturally, my lord, no favorable response to the notice. So, my lord, I file a suit. My lord, I'll place the plaint, my lord, before your lordship because it's important. Yes. Yes. Now, my lord, defend number 2. My lord, my lord, the tenant, my lord, who was the respondent number 2 in their application.
Only.
Yes, because
or both the assigners.
No. Only, my lord, the tenant. My lord,
the assignee.
Yes, my lord, he had taken over all rights. And, my lord, I recognize him, my lord, as, my lord, the tenant. My lord, this was, my lord, the position. Now, my lord, after the suit was filed, my lord, the respondent number 2 in these proceedings, my lord, filed an application under Order 7, Rule 11. My lord, he said, the suit is not maintainable. I am entitled to protection of, my lord, the West Bengal Premises Tenancy Act. Now, my lord, they also filed, my lord, a written statement. My lord, issues were framed. One of the issues, my lord, related to, my lord, my ownership and the relationship, my lord, of landlord and tenant. Am I the landlord of these premises? Are they the tenant of these premises? My lord, that was decided, my lord, in my favor. Yes. Yes. Now, my lord, decree, my lord, in my favor. My lord, evidence was laid. My lord, several documents, my lord, were exhibited.
And, my lord, the judgment, my lord, and decree was passed in my favor on 18th August 2010. Kindly, my lord, just note that date.
Because they filed a suit also, that's why.
Yes, they had a suit, your lordship. Now, my lord, yeah, you're coming. And, my lord,
That suit was after the decree was passed.
yes, my lord. And, my lord, then in the suit, they failed to get an interim order. And then, my lord, they allowed it to be dismissed for default. Of course, the suit wouldn't have.
They have written that they got the injunction.
No, I don't think they did.
They
Or it was vacated, my lord.
the injunction.
Yes.
Later on, they wanted to withdraw. The court
My
did
lord,
not-
since they did not get it, my lord. But anyway, my lord, that's, yeah, yes.
It is after the decree. the
Yes,
suit was-
yes.
Yes, then
Now, my lord, on 25th November, my lord, we filed, my lord, for execution of, my lord, the decree, my lord, dated, my lord, 18th August 2010. My lord, on 29th March 2011, as per, my lord, the bailiff's report, my lord, we were,
resistance was caused by them.
beg your lordship.
When this report says that resistance was caused by them.
Yes, yes. And, my lord, we were, my lord, given possession, and we also lost possession because they moved in.
No. The bailiff gave you a position.
Yes, recorded by the High Court later, my lord. First resistance, then, my lord, possession, then dispossessed. Now, my lord, kindly see what happened. My lord, 29th April, I got possession. 5th April 2011, I'm dispossessed. 29th March 2011, my lord, I'm given possession. 5th April, my lord, get, my lord, dispossessed.
Within 6 days.
Within 6 days. On which day they file an appeal? On which day, my lord, the defendant in my suit, my lord, files an appeal? Now, my lord, the division bench, my lord, again, my lord, in a contested appeal on 23rd March 2017, my lord, dismissed, my lord, the appeal. And the decree for eviction, my lord, was confirmed, my lord, by, my lord, the division bench. And, my lord, not only that, there was an interim order, my lord, which was subsisting during the appeal, where, my lord, occupation charges has been directed to be paid.
And the condition precedent was stayed.
Correct. And
They never did.
no, my lord, they had paid those my lord, they were in possession, which is why they paid. My lord, the defendant in my suit, my lord, accepted that as occupation charges and paid. My lord, it gets curiouser and curiouser. My lord, I'll just show your lordships, my lord, the documents they have enclosed.
I'm just thinking about the height. To what height it can go.
Yes. Now, my lord, they had, my lord, deposited these occupation charges. And, my lord, the division bench, when disposing of, my lord, the matter, my lord, noted that occupation charges had been paid and that it should be made over to, my lord, my client. Now, my lord, we again, my lord, filed, my lord, application for proceeding with the execution case. And, my lord, the defendant number 2 in these proceedings, the respondent number 2, opposite party number, my lord, they filed, my lord, who was the defendant in my lord suit, an objection to, my lord, the application for execution. In the meantime, this is on 23rd June. My lord, in the meantime, my lord, they also file a review application. So,
Review of these.
my lord, division bench order.
Yes.
23rd March 2017. Division bench order. So, my lord, we.
Then
Yes. 11th August 2017. Then, my lord, we, my lord, applied for police help. My lord, in our, my lord, execution. Considering what had happened, my lord, in the past. About, my lord, being forcibly dispossessed after bailiff had given us, my lord, possession. Now, my lord, kindly see, my lord, the ingenuity. On 6th January 2018, within 2 weeks of my filing, my lord, an application for police help, they said, well, execution application does not lie. We are making an application now. That decree was satisfied because possession was given over. So, my lord, the defendant in my suit, my lord, the judgment debtor, my lord. The judgment debtor filed an application for dismissal of execution on the ground that the decree stood fully satisfied
since the decree holders recorded possession of demised flat in execution of decree and copy of bailiff's report of 29 March was relied on. Now, my lord, on 13 September, my lord, my application for execution got dismissed because the decree had been satisfied. That was the finding, my lord, of, my lord, the learned court below, the executing court. So, my lord, we filed a revisional application, my lord, before this honorable court. My lord, that was on 4th December 2018. Against, my lord, the order of 13 September 2018, which had dismissed, my lord, my execution, saying that your decree is being satisfied, you cannot maintain an execution. My lord, that, my lord, revisional application was allowed, my lord, by this honorable court by an order dated 16th January 2019. So, my lord, we've traveled 9 years, my lord, till, my lord, that date, 16 January 2019. And, my lord, a direction was given, my lord, by this honorable court, my lord, for, my lord, to dispose of, my lord, the execution petition, my lord, expeditiously within a month. And, my lord, police help, my lord, was also, my lord, permitted, my lord, in that order itself. My lord, in, my lord, that, my lord, revision. I'll place, my lord, the order, my lord, of, my lord, that court. Now, my lord, we get a letter from the judgment debtor that, my lord, this is on 12th February 2019, that, my lord, the judgment debtor, which was a partnership, has now become a unit, my lord, of a company known as CART Infralog Limited. Now, my lord, CART is Central Area Road Transport.
Oh, I was thinking differently.
No, no, my lord, it's all.
From a big, the goods vehicle, they have now shifted to cart.
My lord, so my lord, it's Central Area Road Transport Infralog Limited. We are informed in 2019. In fact, they have disclosed documents, my lord, that this company is incorporated in 2011. And, my lord, the partners of, my lord, naturally, because if it's a unit, my lord, the partners of the judgment debtor were directors of that. They're all areas. Now, my lord, the judgment debtor, my lord, filed another application. It's another chance, my lord. Filed another application being Miss Case 41.
Under section 47.
Yes. Praying that, my lord, the execution case, my lord, to be dismissed and for the decree to be declared a nullity. My lord, straight after that, the special leave petition, my lord, which they had, my lord, filed, my lord, against, my lord, the revisional order, 16 January 2019, my lord, was dismissed, which had directed, my lord, execution, my lord, to
Bible of the execution
correct,
case and the
correct,
disposal thereof.
correct. Now, my lord, then, my lord, comes, my lord, the applicant, my lord, in the order 21 rule 97, filing a title suit.
After SLP.
Yes. My lord, 16 September.
I was not, my lord, innocent. They does not mean.
No, I have not.
I understand. Applicant is a new entity.
Yes.
You are giving an independent right, sir. Otherwise, order 41, order 21, 101 will not come.
Yes.
You can't. Judgment debtor cannot take recourse to order 21 to 101.
Now, my lord, when I said they, my lord, I meant, my lord, the applicant. No, applicant, my lord, applicant.
Applicant.
Because, my lord, I see, my lord, only my learned friend here. Who is they, my lord?
That's arbitration concept of group of companies.
Yes.
Don't borrow that.
Yes. Now, my lord, the applicant, my lord, filed, my lord, a title suit.
my lord, claiming to be in occupation of the demised flat all along, while the respondent number 2 was in occupation of only a portion of the demised flat. I'll place that suit. Decree and judgment of eviction dated 18th was obtained by fraud and collusion, not binding on it, and sought, my lord, an ad interim order of injunction of stay on the execution proceedings. My lord, subject to correction. Subject to correction, my lord, by an order of 18 September 2019, my lord, ad interim relief was refused. My lord, by my lord, the learned judge. Then, my lord, fairly recently, my lord, the suit stood dismissed for default on, my lord, 5th of February 2024.
In your presence or in your absence?
In our absence. In our absence. Now, my lord, on 18th September 2019, my lord, there was a judgment and order dismissing, my lord, Miss Case 41 of 2019,
Section 47.
Correct, which had been filed. And, my lord, important.
Division was preferred. No.
No, my lord. Now, my lord, then, my lord, we have cart infralog, my lord, of which two, my lord, the judgment debtor has become a unit. My lord, file, my lord, and order 21, rule 97, 99,
and 101.
101. They file. Now, my lord, kindly make a note of one thing. Directors of cart infralog are partners of the judgment debtor. And cart infralog was, my lord, incorporated on 19th of August 2011. And, my lord, cart infralog, my lord, admits that it was in possession of this flat. Admits that it was in possession of the flat. And, my lord, also says that, my lord, the rental was, my lord, initially 6,500, enhanced to, my lord, 13,000. Now, my lord, this Miss Case, my lord, was, my lord, dismissed, my lord, on 25th September 2019.
Merit or?
My lord, on merits. On merits. And, my lord, there is, my lord, no challenge to this. Then comes, my lord, 27th April 2021, my lord, Miss Case 53 of 2021, filed, my lord, by, my lord, the present applicant. Now, my lord, your lordship seen, my lord, the application. If I may, my lord, just summarize 4 points, my lord, apropos this. My lord, it was admitted that the rent of the suit flat was, my lord, 13,000. Second, my lord, that, my lord, judgment debtor was never in possession of the suit flat, but was actually in possession of the adjoining terrace, which is known as the terrace flat. And, my lord, the applicant, my lord, was paying rent to Tinwald, even though it had been dissolved from 1st of July 1980, and claimed, my lord, that, my lord, the applicant was the rightful tenant of, my lord, flat number 93, which had 12th, 13th, and 14th. This is, my lord, their case. Now, my lord, this application initially, my lord, was dismissed, my lord, by, my lord, the civil judge, senior division.
Executing court.
Correct.
Yes.
By the executing court. My lord, that was, my lord, on 15 January 22.
Challenge.
My lord, I just want to indicate the findings. My lord, it was found there, my lord, that some of the directors, my lord, of the applicant were partners of, my lord, the, my lord, judgment debtor. And that the living persons behind, my lord, the judgment debtor and the applicant were one and the same. Second, it was held, my lord, that, my lord, the applicant and the judgment debtor had filed several miscellaneous cases, one after the other, to delay, my lord, the execution proceedings, and had continued to enjoy the demise flat without payment of, my lord, any occupational charges. Third, my lord, that the applicant had complete knowledge of the decree and the execution proceedings. Fourth, despite having knowledge for 10 years, the respondent number 1, my lord, had, my lord, filed the application without any explanation for the delay. The application was barred by limitation, and, my lord, exemplary costs of 50,000, my lord, were, my lord, awarded, and executing were directed to, my lord, continue. My lord, against this,
That was allowed, revision application.
no, my lord, an appeal, my lord, was filed, but not in this court.
Oh, the appeal has to be filed.
My lord, they filed an appeal.
That must have been allowed.
Yes.
Should be allowed. Yes.
Yes, but my lord, the appeal was not filed in this court.
Who is the executing court?
Senior division, and my lord,
What was the value?
1,60,000,
More than or
1,50,000, more than. It was more than. It could only be in the High Court. And that's, my lord, your.
why you did not take that?
My lord, when I, my lord, came into the picture, my lord, the same point was taken before your lordship at the admission stage, when, my lord, I was for the appellant in this matter, where, my lord, we cited, my lord, the, my lord, provisions, my lord, of the Act, and your lordships, my lord, held, there's an elaborate judgment that, my lord, appeal will lie only to the High Court.
Anyhow, it is reverted.
Yes. Now, my lord.
Then what happened? After reversion, you did not challenge that order.
No, we came up. But in the meantime, my lord, there was a direction. My lord, what happened? My lord, though the SLP had been disposed of, my lord, my clients, my lord, filed a miscellaneous application before the Supreme Court, saying nothing is happening, please direct. Supreme Court observed, my lord, at what was happening to my client, my lord, having to run from pillar to post, my lord, directed, my lord, execution proceedings to be disposed of within a period of 6 months. So, my lord, from this order, my lord, which, my lord, it was set aside, my lord, the executing court order of, my lord.
No, appellate court's order.
The appellate 15 December 22, my lord, there, my lord, there was in the meantime another order. My lord, in the executing court, my lord, directed the bailiff to hand over possession to my client after the Supreme Court order.
Yes.
From that, my lord, also, my lord, there was, my lord, an appeal. My lord, we filed a contempt petition, my lord, before the Supreme Court that its orders had not been complied with. And, my lord, the courts, my lord, dismissed, my lord, the, my lord, civil revision, said, my lord, it had, my lord, become, my lord, infructuous, and, my lord, said Supreme Court order, my lord, all proceedings to be heard, my lord, by the executing court. And then, my lord, we have, my lord, the order which has been passed, my lord, in this matter. Now, my lord, kindly come to the order, my lord. Show your lordships, or anything else your lordship wants.
What it says.
My lord, there were, my lord, several issues, my lord, which were framed. And, my lord, I'll go, my lord, very quickly. My lord, 6 principal issues, my lord, were framed. Whether the application itself was maintainable in the present form.
That is the very general way of
General way.
framing anything.
My lord, 1 and 2 were very general, whether the applicant had any cause of action to file the case. Then, my lord, whether the petitioner has any right, title, interest, and possession.
What is the main object of Rule 101?
Correct. Right, title, interest, and possession in respect of decretal property. And, my lord, here, my lord, the first two, my lord, are of course had cause of action, applicant is present. My lord, in issue number 3, where the petitioner has any right, title, interest, and possession in respect of decretal property, my lord, the finding is that, my lord, the petitioner, the applicant, my lord, was a tenant under the plaintiff.
He was a tenant under the plaintiff in respect of
12, 13, 14. Then, my lord, whether, my lord, I am the owner of the suit property, even that was framed. My lord, found in my favor.
That was already.
Yes, again, my lord, found in my favor. Whether the ejectment notice is a
also gone into.
yes, valid one or not, they said, well, served on the wrong person, therefore not valid. And, my lord, whether decretal property is identical to scheduled property of execution proceeding, issue, my lord, really not decided after having held. And, my lord, most important, has held, my lord, that they have not paid a penny, my lord, for being in possession. That finding, my lord, is also there. Now, my lord, what happens? My lord, 2.
How it was held that they are the tenants? There must be some logic and
yes,
some findings. How the court, executing court, came to a finding that they were the tenants, they are the tenants.
Lordships put a very pertinent question. Because my lord, the executing court proceeded on the basis that terrace flat 93
is an independent.
Only means that terrace flat and not 93 with 12, 13, 14. So, my lord, my notice related to something else. Initial agreement for lease, my lord, with Raghuraj Puri, my lord, which was with defend number 1. And it ignores the evidence where, my lord, they, my lord, say.
This flat number 93, according to you, all along was understood as 12, 13, and 14th floor.
Correct.
There was a terrace on the 13th floor, and it is called as a terrace flat number.
Even this is called terrace in the rent receipts.
Now, there appears to be two agreements. One in relation to 12, 13, and 14, reaching a 13,000 now, lastly inadequate. Yes. And there is another agreement relating to that terrace, fetching 500 rupees.
Correct.
This is what it comes.
Yes.
Your suit was 12, 13, and 14.
Yes.
They claim that tenancy right in respect of 12, 13, and 14. The terrace flat was never a subject matter of a decree nor a subject matter of this.
No.
Are they claiming their right in a terrace flat number 2093, or they are claiming their tenancy right in respect of flat number 93 comprising of 12, 13, and 14?
My lord, they are claiming, my lord, that they are, my lord, tenants under 12, 13, 14. My lord, which was the
decree was passed in respect of 12, 13, and
14.
Not in respect of a terrace.
No, not in respect of just the terrace.
Then why the executing court held that this decree is restricted to this terrace?
My lord, they said I've sued the wrong person.
Wrong person means then they must show that they have paid rent when they were they entered into an agreement for lease.
Correct.
What was the finding of the executing?
I'm showing your lordship, my lord. Kindly have a look.
That they paid, how they paid rent.
My lord, kindly have a look.
That rent comes.
My lord, kindly have a look, my lord.
And how the rent receipt was issued.
My lord, kindly have a look.
I tell you very, very frankly.
Yes.
There are two distinctive facts.
Yes.
The rent receipt issued in the name of person, whereas the rent is remitted by another person. It so happens.
Can happen.
It happens.
Yes.
That rent is remitted by somebody else.
Yes, ma'am.
It is the one aspect.
Yeah.
Second aspect is very plain and simple. Rent receipt issued in the name of a person. Rent is remitted by that person. Have they issued, they produced any rent receipt issued in their name?
No.
By your predecessor?
No.
Or by you?
No.
After taking? And remittance was also done by them.
Yes.
But then how the executive court arrived at the conclusion that they are the tenant?
My lord, kindly, my lord.
What was the finding? How this has arrived?
My lord, simply on the basis, my lord, that it's terrace flat. Terrace flat will only refer to you've sued the wrong person.
But terrace flat was not a subject matter
Of the suit.
Then it was in relation to a decree which is there.
Yes.
Not in relation to something else.
So, my lord, what has to be shown, my lord, is, my lord, that the in respect of the suit property,
Correct.
my lord, the applicant
Has an
was,
independent right.
yes, has an independent right, was the tenant,
Yes.
had, my lord, made payment and obtained, my lord, rent receipts from me,
in its name.
in its name from me, because my ownership, my lord, is established.
What law you want to say?
No, I don't want.
What order 41 rule 27 you want to say? What are the documents you want to
Yes,
compare?
my lord, kindly, my lord.
What the nature of the documents? Is?
My lord, one is, my lord, order 7, rule 11, application filed, my lord, by, my lord, the defendant in my suit, where he's annexed, my lord, the, my lord, bill,
Rent bill.
rent bill, my lord, which is, my lord, in the name of, my lord, the defendant, describes, my lord, 12, 13, 14 as terrace flat and shows rent as 13,000, which is the admitted case, and says, my lord, that he comes outside the purview of, my lord, he is entitled.
Why you did not produce that at the time of the suit?
I could have, my lord, I am not. Second thing, and this is important, my lord, there is a letter which only they could have had and they should have produced. My lord, is, my lord, Raghuraj Puri's, my lord, letter, my lord, to them, my lord, indicating
the judgment letter.
No, to, my lord, the applicant, my lord, that is, my lord, I'll just kindly give me a minute. Why have you taken away?
Why he will write to applicant?
My lord, a letter, my lord, from, my lord, the previous owner,
Puri.
Puri,
To why applicant?
because they were initially the lessee under him.
Applicant was
Yes, the lessee under him, my lord.
1980.
1980, my lord, in 81, my lord, after the gift of 14th August 91, he writes to them, my lord, saying, my lord, that he has sold the property, gifted the property to me, and that rent should be paid to me.
Then why you did not implicate them as a party in the suit?
My lord, they'd given up their tenancy. The letter is there, which has been accepted by the court.
Given up the tenancy means they surrendered the tenancy.
My lord says from now on, judgment debtor will be the tenant. Yes.
The assignment.
Yes. Yes.
Yes. That letter was marked exhibit.
Yes.
How?
Your lordship.
How?
My lord, it was, my lord, proved by the plaintiff.
By formal proof.
Formal proof. Formal proof.
Or on admission.
My lord, formal.
Without objection. These are the three modes.
Yes.
Of exhibiting a document.
Yes.
I wanted to know.
Yes, my lord, I'll just check, my lord,
from the lower court, the trial court record has come. Has been. How it was marked? Is based with or with objection, without objection, or on consent, or admission. They call it on admission.
My lord, exhibit number 3, my lord, in deposition, which is convenience compilation, page 70. My lord, kindly have a look.
What? How?
My lord, I'm just looking at it.
71.
70 and 71.
No, we will not get it from here.
I'm first showing, my lord. I'll show the deposition, my lord.
No, we can get it only from the deposition or the order sheet.
My lord, I'm coming to the deposition, my lord. Give me Saroj Thakkar's deposition.
Position.
70. My lord, kindly come to page 74.
No, I have seen the exhibits. You will not get it here.
No, it's a deposition.
74.
My lord.
74. Okay.
My lord, kindly come to page 75.
In meaning alphabets of 73. Let me cross over.
Oh, yes, my lord, AB.
Yes.
My lord, kindly 74, the deposition starts.
Where
My
is
lord, of
the-
27.
where is
My lord,
the
page 75, my lord.
Exhibit. This is exhibit.
3, my lord.
No, this was not exhibited there.
Of course it was. All exhibits of the first suit were marked as exhibits, my lord, in their application.
হ্যাঁ, আমার সেটা কোথায় হলো?
My lord, kindly have a look, my lord. My lord, previously the name of the, my lord, last 7 lines. Previously, the name of the defendant company was Arya Central Transport of India Private Limited, which subsequently changed as Central Arya Road Transport, and they informed the same in writing to us, which we received in official capacity. This is the said original letter, which was received by my daughter, plaintiff number 2, as one of the owners. It bears the signature of R.P. Arya. This is said letter without date, marked as Exhibit 3.
This can't be.
This is Exhibit 3.
Do you have the order sheet of this suit?
হ্যাঁ।
I want to see the order dated 27th April 2009.
দেখি। But kindly also look at, firstly,
No, it is in a status suit. I know.
yes, it was not exhibited in my application.
Sir, I know it is in the title suit. I know.
May I, my lord? I
Not
do.
an execution proceeding, your miscellaneous case.
May I?
Yes.
My lord, lordships have seen, my lord, page 74 onwards. Kindly come to page 77.
Yes. Yes.
Same deposition on a different date.
Which one?
74 and 77. With some changes here and there. Now, these are not certified copies. 74, kindly, I will show your lordships the differences, some differences. Kindly come to the second paragraph, third paragraph. My name is Saroj Thakkar, wife of so-and-so. Next, I am plaintiff number 1 in this suit. Plaintiff number 2, Gayatri Dotto Thakkar, is my daughter. Kindly come to page 77. I am plaintiff number 1 in this suit. Plaintiff number 2 is my daughter. May not be very relevant, but there are other changes also.
There is a page 78 also talks about exhibit 3.
That's true.
Different language.
That is exactly what I'm trying to point out. Which one to rely on, my lord? I really do not know.
I tell you, there may be a this is recorded in. Was it decreed ex parte?
No, contest. My lord, I will show the order also of the day.
When it was the set aside and then the contest.
Nothing was set aside, my lord. I succeeded.
No idea.
There is a possibility of the evidence of EW1 twice in a suit. One at the ex parte stage, what he deposed, And secondly, after setting aside the ex parte, he deposed as PW1 again.
Yes, now yes.
So there will be two possibilities.
Yes, so I will show both the orders, my lord.
What I was asking was it decreed ex parte at any point of time?
No, no.
And it was set
No,
aside?
no.
Because I find the gap is nearly 1 year.
Show me the order.
Because I find a variance at page 74 and at page 77. There is some variance.
My lord, my understanding is it can happen. It's set aside and then again, my lord, evidence is laid. While it's set down for ex parte hearing, later it's not ex parte hearing. My lord, evidence starts again. My lord, I have appeared in the lowest of lowest courts, my lord. Let's be very clear on that.
No experience.
No, I have. My lord, we earned our bread and butter there, my lord. We didn't earn it here. My lord, the sad thing is, my lord, we didn't go to city civil court from this high court. We should have gone more often. We used to end up, my lord, in district courts rather than go, my lord, next door, where, my lord, we would have, my lord, been better off.
No, district courts
No, my lord, in terms of travel time, my lord, it was next door.
No, that we were not
Can
allowed.
you find out why there is a disparity in the evidence? Because of what I find is that's why I'm asking you there is a reason.
No, your lordships.
He stated her age at page 74 and then 1 year.
My lord, your lordship is.
So naturally,
My lord, what has fallen from your lordship, my lord, is exactly correct. My lord, it had been set down for ex parte hearing. My lord, on the first day. Kindly come to, my lord, page 85. Lordship wanted to see, my lord, the orders. My lord, I am showing your lordship the orders.
Has to be, otherwise, yes, this was 27th April.
Yes, middle, my lord.
Yes.
Plaintiff files lawyers.
I told you that.
My lord, I am saying your lordship's correct. Your lordship has to give me time to react.
Page 85. The order at date. Which one you are looking? No. It's compilation.
Compilation.
No. It's compilation. No.
Compilation of living document.
না আমি কিন্তু এভিডেন্সটা এক্সপাঞ্জ করলো
অন্য আছে এটা ডিফারেন্স there is a difference
1 to 2.
Yes, that's what I said, my lord, which is why I checked with your lordship whether the correct.
যেটা 255 your first page is up to page 255.
Yes, that's the correct one.
It was from taking off the suit from the ex parte board and then.
But the evidence was not expunged. Generally, তো কোনো ওটাই নেই রে। Six chapters.
Then after an amendment is brought to the Code and Procedure in 2002, the written statement after evidence is accepted. The cost of ₹1,000. I got it. No difficulty. There is a
And my lord, I just,
We can safely go on 77 because 77 is the,
yes,
because in their presence it was.
yes. And my lord, not just that,
77 is the correct one, page 77.
and my lord, kindly come to,
And they did not raise any objection.
no, my lord, kindly come,
Not they, I mean the judgment letter did not raise any objection.
no, my lord. My lord, now, my lord, kindly take, my lord, I just want to, my lord, show your lordship, my lord, the impugned order once, just one paragraph of that. My lord, kindly take the memorandum of appeal. My lord, it's brief, my lord, memorandum. My lord, kindly take, my lord, page 4, my lord, of, my lord, the impugned order, my lord.
Yes.
My lord, after the issues, your lordship will find evidence adduced by the petitioner. Lordship has that, my lord?
Yes.
Kindly turn over the page, my lord. Exhibit 7. Certified copy of plain and exhibited documents of title suit number. All before.
That has to be, it is automatically, it will go. There is no difficulty.
Order 41, Rule 27. Is this mine?
Yeah. That came from their side.
Yes.
The petitioners means they.
Yes, yes.
Yes. Did not produce any document.
No.
Yes.
Lord, our entire evidence, my lord, was, my lord, before the court, what we had.
Yes.
My lord, there are, my lord, your lordship wanted to know, my lord, about Order 41, Rule 27, my lord, the nature of the documents. My lord,
That was already marked as an exhibit.
that was, there was another letter to the same effect.
Assignment letter.
Yes, my lord. What was, my lord?
It was already there.
My lord, to,
why you wanted a.
my lord, to another, my lord, the what, my lord, mother and daughter, my lord, who were, my lord, the, my lord, one was to the daughter, one was, my lord, to the mother. And, my lord, there's a letter, my lord, from, my lord, the landlord, original landlord with whom, my lord, the agreement for lease was entered into, my lord, by, no, Raghu Rai, Raghu Rai Puri, my lord. My lord, that, my lord, letter, my lord, to the applicant, my lord, saying, my lord, that a gift has been executed, you please make payment of rent. Atonement. Correct.
That is an admitted, sorry, I mean, it was at all.
Yes. They, in fact, in the application have challenged the gift because they had to challenge it to, my lord, say, my lord, that they were entitled to deposit rent with 10 volt. My lord, the gift in my favor by my lord.
Because of the loan having not.
Yes, and my lord, the rent being, my lord, put in with 10 volt. Now, my lord,
Why they have filed the cross objection that you are not the landlord?
my lord, one is that, and the other is, my lord, that they have paid rent. They say they have paid rent to retain wall. That finding is bad.
And your right to claim rent is also challenged. Where the
Yes, 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 yes.
Yes. Anything?
My lord, the Order 41, Rule 27, my lord. My lord, one I said, my lord, is that Order 7, Rule 11.
Understood. Order 7, Rule 11, the judgment debtor himself or itself has admitted
Correct.
the position. He relied upon that.
Yes.
Second thing is the letter of atonement to the daughter.
Yes.
I mean the niece.
Yes.
Given by the Puri.
Yes.
These are the two documents you want to rely upon.
Correct.
And what was given to a sister is already marked exhibit.
Yes, my lord. And my lord, that my lord, my lord, there are two others, my lord. Huh? Yes. Yes, my lord, which we didn't have, we've got from Raghuraj Puri, my lord, is that for the terrace flat, my lord, which they say they had given up, and not, my lord, the suit flat, my lord, they have been paying rent to Raghuraj Puri of 500 rupees, which we couldn't have had, my lord.
Even after 1991.
My lord, this is 6 January 2000.
They say that where is Raghuraj Puri, nobody knows where he has gone. But you could get the.
Yes, my lord, my uncle, my lord, from his office, my lord. He is, my lord, I think in his 90s. The sister is also close to that, my lord, Saroj Thakkar, and the daughter is Gayatri.
Anything more?
My lord, that's.
Any judgment you want to rely upon?
No, my lord, my lord, we should know where to cite and where not to cite. I was just. My lord, another very important fact. My lord, the judgment debtor was made an party, my lord, to these proceedings. My lord, kindly have a look at the impugned order. Judgment debtor, my lord, vanished.
Oh. It did not, the judgment debtor did not contest and appear.
My lord, that's recorded. My lord, in the order itself. Show me that portion. Come on, follow me. My lord, the heading is conduct of opposite party. That same page, my lord, page 4 and 5, my lord, have everything. Opposite party number 3 did not appear after service of summons. Petitioner filed AD card in support of service on 10th August 2020. That's somebody who had contested all along, right up to the Supreme Court.
Without being in possession of the property, that's
yes, sir.
Interesting.
And not just that, paid occupational charges.
Without being in possession.
Yes.
They claim
Yes.
to be in possession
Yes.
throughout.
Yes.
What do you have to say about the impeachment of an assigner in a suit for eviction?
My lord, kindly have a look at that letter once. My lord. Kindly have a look.
No difficulty. It is assigned. All my rights which I have is hereby assigned to this.
My lord, one is a question of privity of estate, another is
of state and privity of contract. I am talking about the privity of contract. So there is a dedicated chapter in the Mullas
Yes, yes, yes.
Property Act. You will have to.
Yes.
The graph has been made. If I correctly remember, I read it.
Yes, my lord, it's
20, 30 years before. And whether the assigner is to be made a party.
My lord, your lordship will find, because my lord, there was a
party. The assignee was a
yes.
defendant in the suit.
It says, my lord, we have transferred our leasehold rights, title and interest in favor of so and so. which are ex-directors or partners.
Tenancy is not a transferable right. If it is a lease, if the lease is assignable,
Correct.
it is assignable under section 108, the rights and liabilities of the lessee is already.
My lord, those continue.
Created, then
Those
also
continue.
the lessee should be made a partner.
But here, my lord, it's a tenancy, my lord, at the end of the day, because, my lord, it's unregistered document.
So the magical charm into the word tenancy under
No,
the PPI.
it's a month by month, my lord, month by month lease. It's a month by month.
It was whether it was really an holding over under section 112 of the TPI. When they say the after of the initial.
No, that's not the case. That's not the case.
Secondly, is an unregistered lease agreement for a period of more than 1 year.
Yes.
Whether admissible in evidence or not is another question. The document which is compulsory registrable has not been registered.
They should have taken objection then. And, yes.
Complete bar. Only exception is collateral purpose. What is the collateral purpose? To ascertain the nature of the enjoyment. Nothing
Yes.
more than that.
And the rent.
That's all.
Yes, that's the rent. So this is the rent, and
can also not be gone into.
Yes.
So that is what is a monthly lease.
Yes.
Running on the payment of the rent from month to month. And determinable under section 116 by a 15 days notice.
Correct.
Not agricultural lease.
No, it's not.
What do you have to say about this? Assigner not being made a
My
part.
lord, I'll tell your lordships, kindly have a look, my lord, at the document once.
And I have transferred all my rights to.
No, not something slightly more, my lord. As such, so-and-so has become the lessee of the flat. So it's an arrangement, my lord, which is tripartite in nature and acted upon.
What is the assignment? Same thing.
Yes, no, but my lord, there, my lord, the privity of estate, my lord, it runs along with the land.
That's true. That is when a subtenant comes.
Correct.
The privity of contract.
Correct.
Contract remains with the assigner.
Correct.
Not make an assigner a part. Even if he has.
And my lord,
the larger issue I tell you.
Yes, of course.
Issue. Some judgment says yes, some judgment says, old judgment says yes, some judgment says no. So I do not know. There is a divergent views. Anyhow, they have not taken this.
No. No, let them take the plea, my lord. I will deal with it if they wish to. Because, my lord, it says, become lessee, you shall as such be issuing bills to so-and-so and payments will be made by them to you directly. And this is, my lord, accepted and acted upon. My lord, bills raised, my lord, rent also, my lord, paid by them. And, my lord, apropos that, my lord, we've given more documents in, my lord, Order 41, Rule 27. Because this issue was not denied, my lord, by, my lord, the defendant in, my lord, the suit.
There are two aspects. One, Order 41, Rule 27.
Yeah.
Whether those documents were tendered in evidence, not admitted in evidence, then you can bring it by way of an additional evidence, which ought to have been received in evidence, has not got not. Secondly, due diligence concept has come. Despite the due diligence, you did not have the knowledge of this document.
Couple of them fall in that category.
And the third one is if the
court,
some other reason,
well, that's what I
require.
Well, that's
for pronouncement of the effective judgment,
correct.
that the court can also take it.
Yes. Which is why, my lord, the view has been that it should be heard with the appeal.
So we have to consider whether the court requires those documents.
Yes. Lord, I can show those documents.
What are they? You have said Order 7, Rule 11, filed by the judgment letter,
yes.
containing that letter,
yes.
which you want to rely
yes,
upon as an evidence of
yes.
evidence. Second is another letter to a niece by Puri. Though the letter issued by Puri to her sister was marked exhibit.
Yes.
So it's a
my lord, niece was exhibit and my lord sister, my lord.
Ocha. The niece was an exhibit.
Yes, my lord, who's also a plaintiff, my lord.
Now it's a mother.
Yes, my lord. I just want to show your lordship, my lord.
So let us see if they took a very serious point on this. then we'll consider whether those are required. Otherwise, assignment is there.
Deciding at entry 43. So that rule is that
Yes. And my lord, there's one subsequent event, my lord, which has come to light, my lord, which we have included, my lord, in my lord, one, my lord, today, the judgment debtor is a unit of, my lord, cart lock,
That's cart.
cart infra lock, my lord, limited. My lord, one of their directors, my lord, resigned. My lord, one gentleman called Banwari Lal Sharma. And my lord addressed the letter of resignation, my lord, to my lord, flat 93, 12th floor. 12th, 13th, 14th is where my lord judgment debtor was. It's addressed there, and this is 15 July 2019. And which was accepted by a board resolution of 18 July 2019.
Uploaded in that, I do not know.
MCA website.
Form 13 or something.
My lord,
What was there?
yes, my lord, earlier Form 32.
Form 32.
Yes. Now, my lord, all that's changed, my lord. MGT 12, my lord. Management forms, form number 12, MGT 12.
So there also they have shown the address.
Yes, that's where they are. That's where their director's writing when he resigns, and that's uploaded, my lord.
So you want to rely upon this document as an additional evidence
To show that one was
subsequent event.
correct. My lord, the applicant was never there. It was, my lord, the judgment debtor. Judgment debtor's director, my lord, is, my lord, writing. Addressing the letter to 12th floor. That terrace flat is 13th floor, even according to them.
Like a Caesar's to a Caesar's wife.
And my lord, these, my lord, triple flats, my lord, 12th floor is the entrance. Then, my lord, it goes up to, my lord, 13th, then 14th, with the inside staircase. So, my lord, it's addressed triplex, my lord.
Not duplex.
Not duplex. Duplex, 2 floors, my lord.
That's all?
Yes, I don't think, my lord, I can. My lord, may I have your, try and save something, my lord, may I have your lordship's leave.
May I place the petition? My application?
I've already read. The relevant portion, you just tell me what you really want to say.
Very well, madam.
Just tell me what you really want to say.
I'll tell you.
What's your case?
I'll tell you, lordships. Admittedly, I would say admittedly, there were 2 tenancy agreements.
One in 1980 and another is 1982.
82. One in 1980 was in respect of a triplex flat.
And another is a terrace flat.
The other one is a terrace flat. I'm obliged.
No problem.
Assignment,
In respect of
terrace flat.
terrace. Can you show from the data from that assignment letter that it was only in respect of a terrace flat?
Kindly come to the document, my lord, once. Page 70. 70.
Yes.
Dear sirs, read at the top one.
Yes.
Read terrace flat.
Right. Yes.
Please be informed that we have transferred our leasehold right, title, and interest in respect of the above referred flat in favor of Central Area Road Transport, a partnership firm with effect from such and such, in which our ex-directors DN Arya and Sanjoy Arya were, are partners. As such, the Central Area Road Transport has become the lessee, etc. legal implication of this, I'm not going into this.
Let us see.
For the
Let us-
time being,
let us-
so
let us see that this
assignment,
let us say this assignment is restricted to a terrace flat.
yes,
Not
yes.
the suit was
For the triplex flat,
of triplex.
yes,
Now the triplex flat.
yes.
What is your independent right in respect of a triplex? Let us see. This was assigned. They have not gone for a decree against this. They have not.
Yes.
They say this right was never gifted to us by my brother or an uncle. The deed of gift is relatable to a triplex flat only.
Very well.
So I have filed a suit
Yes.
for recovery of possession in respect of a triplex flat
Against
against the
partnership,
against the defendant,
against the partnership.
against the tenant. Let us see
No, against the tenant, not of triplex flat.
what
Against the assignee of the terrace flat.
who was the lessee of 1980. Tell us.
Me. The applicant before your lordships. Kindly come to that document once, my lord. I will not take long. Kindly come to page 58.
Yes.
58.
Yes.
Agreement to lease dated 1st September 1980 between Raghuraj Puri of the first part, Srimati Lalo Puri of the conforming party, and then Arya Central Transport of India Private Limited. That is me, the lessee.
Yes.
Then kindly come to the, my lord, first, second, third recital. And whereas the partners of the said Teen World Properties, namely the said Ved Prakash Mehta, Prithviraj Bakshi, Raghuraj Puri, Pradeep Mehta, Pradeep Raj Bakshi, and Srimati Lalo Puri entered into a mutual agreement on 6th May of 1980, whereby they divided all the flats and... No, sorry, my lord, kindly bear with me for a minute.
Yes.
The submission was, my lord, Teen World was dissolved. That is not the case. The partners merely, my lord, distributed some of their properties amongst themselves. Then kindly come to the next recital, my lord. And whereas by the said agreement, flats mentioned in Schedule A, Lot 6, were allotted to Sri Raghuraj Puri, the party hereto of the first part, which comprises flat number...
Mr. Puru, you know, it's a contract of a lease or a contract of a tenancy.
Yes, my lord.
If you got the position
Yes.
from a particular gentleman,
Yes.
then in that event, it is your obligation to pay rent to that gentleman.
Yes, I shall.
So the Puri who inducted you
Yes.
is entitled to receive rent from you.
Absolutely.
Whether the Puri had a absolute right in the property, you cannot now come forward and challenge that the Puri did not have.
I am not doing...
116 of the old Indian Evidence Act, the estoppel is against you. Now the payment to a tinward, when the lease was executed by a Puri in his individual capacity.
I am not trying to do that, my lord.
That is what you wanted to say.
No.
That you have paid to a tinward.
No, this submission before your lordships was...
Tinward is dissolved or not dissolved?
That was the submission. That is why I said... Yes, very well. Kindly proceed on that basis. Kindly come to the next sub...
Yes.
Kindly, my lord, kindly give me some time.
Yes.
Next, page 60, the last paragraph. And whereas by the said agreement, flats mentioned in Schedule A, Lot 6 were allotted to Sri Raghuraj Puri, the party hereto of the first part, which comprises flat number 93 triplex flat in Block B of the said Tivoli Court.
Correct.
So this was the subject matter of the 1980 agreement.
True.
Yes. Now kindly come to, my lord, the 82 agreement once, my lord, which is at page 165. Again, between the same parties.
I understand.
Now kindly come to page 167. The first recital at the top. And whereas by the said agreement, flats mentioned in Schedule A, Lot 6 were allotted to Sri Raghuraj Puri, the party hereto of the first part, which comprises flat number 93 triplex flat in Block B of the said Tivoli Court, and also 1,000 square feet of terrace with unfinished structure standing on a part thereof, adjoining and or adjacent to the said flat number 93 on the 13th floor of the said premises. Completely two separate tenancies. And the tenancy assigned was the terrace, not the triplex. Now, so many things have been said, my lord, your lordships were not shown the objection filed by them.
Let me go through that.
Yes, yes. Please. If your lordship allows me to assist, my lord, lordships. Very well. Lordship should kindly look into the Havendum, my lord, starting at page 169, Havendum clauses. Clause 1.
Yes. Yes. What do you want?
So, my lord, there were two separate tenancies in favor of, my lord, the applicant before your lordship.
Yes.
One was, my lord, triplex flat 93. The other one was terrace flat 93. And my lord, terrace flat 93 was assigned. Terrace flat 93 was assigned. They filed the suit in respect of the triplex flat. Kindly look into, in this context now, my lord, kindly look into my application and their, my lord, written objection there too. My lord, kindly come to my application, my lord, which starts at page 134. Your lordships have seen that. May I show, my lord, some for my satisfaction?
Let's say that you can summarize what you
Yes,
really
yes.
want to say.
Kindly come to.
Summarize it.
Kindly come to, my lord, page 140. Paragraph 11. Ultimately, the said flat number 93, comprising of 12th, 13th, and 14th floors of the building Tivoli Court, was allocated to Raghuraj Puri. Then 12, on or about 1st September 1980, the said Raghuraj Puri made an agreement to lease with your petitioner, then known as Arias Central Transport, and thereby he granted to them an unregistered agreement to lease for 3 consecutive terms of 10 years lease and any unexpired term at a monthly rent of such and such, with renewable clause in respect of the said flat number 93, comprising of 12th, 13th, and 14th floor. Then 13, the petitioner's tenancy in respect of the said premises become a monthly tenancy, etc. Then kindly come to 14. Again, on or about 1st June 1982, the said Mr. Raguraj Puri granted to your petitioner, then known as earlier Central Transport of India Private Limited, another tenancy by entering with them into another unregistered agreement to lease for 3 consecutive term of 10 years lease and any unexpired term commencing from 1st June 1982 at a monthly rent of 500 in respect of a different premises being 1000 square feet of terrace with unfinished structures on the 13th floor, adjoining terrace and adjacent to flat number 93. Then kindly turn the page, kindly come to paragraph 17. Your petitioner completed the said unfinished structure by constructing the same into a flat of the terrace. The said completion of the structural work was made after taking the said tenancy under the cover of agreement of lease. Thereby the said tenanted terrace with structure came to be property identified as terrace flat number 93 at Tivoli Court. The said terrace flat number 93 nonetheless thereby became separate unit of tenancy under the said Raguraj Puri. For this unit of tenancy, the said Raguraj Puri duly accepted rent from the petitioner month by month and every month, as and when the same became due. A copy of the agreement, etc., between are annexed. My lord, this was, then my lord, kindly come to paragraph 21. It is therefore crystal clear that your petitioner's tenancy of flat number 93 comprising of 12th, 13th and 14th floor of Tivoli Court was an independent unit of tenancy at a monthly rent of rupees 13,000, quite distinct and separate from the other unit of tenancy of terrace flat number 93 at the said Tivoli Court at a monthly rent of rupees 500. Thereafter, your petitioner underwent change of name, etc. My lord, kindly come to page 146. The tenancy in respect of flat number 93 comprising of 12th, 13th and 14th floor at Tivoli Court was never assigned by your petitioner to the judgment data Central Area Road Transport, but has been retained by your petitioner till now. The petitioner's tenancy in respect of flat number 93 comprising of 12th, 13th and 14th floors still continues legally unaffected, though illegally threatened by ouster of eviction decree enforced by title execution in execution case number such and such in favor of the opposite parties number 1 and 2 and against the opposite party number 3, Central Area Road Transport, a stranger who was never a tenant nor otherwise connected with flat number 93 comprising of 12th, 13th and 14th floors of Tivoli Court at premises number 1C Baligan Circular Road. Then, my lord, your petitioner's possession, etc. Now, kindly come to their objection. Written objection, my lord, which starts at page 215.
Transfer of terrace flat.
Sorry, my lord.
34. Last paragraph.
Sorry, my lord, one more paragraph I missed. Kindly give me page.
Page 146.
Kindly come to page 146 once. Sorry, paragraph 34. Paragraph 34, my lord, page 146. The judgment debtor opposite party number 3, Central Area Road Transport, at no point of time was a tenant in respect of the said flat number 93 comprising of 12th, 13th and 14th floor at Tivoli Court, but was a transferee tenant of the terrace flat number 93. Now, my lord, a submission was made that this defendant is not appearing before your lordships. Now, kindly see, look into, my lord, the address given in the cause title of the memorandum and the cause title given, my lord, in the Order 21 Rule 97 application. Those are different. The old address of, my lord, the defendant has been given. Now kindly come to their once, page 215, their objection. Well, let kindly come to page 215, paragraph 3. The executing court cannot go behind the decree. However, certain facts are narrated herein in support of my above said contention. A. We filed a suit for eviction being title suit number 18 of 2007 in the Court of Learned Second Civil Judge Senior Division at Alipur against this opposite party number 3. Said suit was subsequently transferred. Then B. In the said suit, we specifically pleaded in paragraph 4 of the plaint that by a letter dated NIL said area Central Transport of India Private Limited informed to the plaintiffs, and accordingly the plaintiffs started receiving the monthly rent from the present defendant. My lord, kindly pausing here for a moment. Kindly give me a minute's time. Sorry. Then, my lord,
Is there anything missing in the evidence of their first witness?
no, nothing else.
Everything is there.
No cross-examination.
Cross-examination.
No cross-examination.
This is the only cross-examination.
Yes. And no examination of the ballot plaintiff's evidence, witness.
Did not come to the box.
Nobody came to the box. Well, forgetting about evidence, kindly look into the objection. Kindly come to my lord, I was at page 216. Kindly come back to page 216.
I have already read their objection.
There is no, my lord, denial in that sense of my case. Now, my lord, many things was said about, my lord, what happened between 2010 and, my lord, 2021. Now, my lord, there is not a single document to show, my lord, that I was at fault or I did anything. I means, my lord, the applicant before your lordships. There was a, my lord, division between the directors or, my lord, the persons in control of the applicant. Somebody went out, so a flat was given to him. After that, my lord, the aspersions which were made that, my lord, I am behind everything. Or, my lord, it can also be the case that, my lord, the defendant was, my lord, taken control of. Sham defense, some cross-examination, nothing further. They knew everything.
Order voluntarily depose order.
There is order to the effect recording that, my lord, the plaintiffs, my lord, voluntarily said that they will not depose. They will not come to box.
In this application.
In my application.
It is not being discussed.
হ্যাঁ তো order তো দেখিয়ে দিতে পারি। Sorry. আচ্ছা এইটাই বোধহয় স্টিচ I can show you, Lordships, the order. I have certified copy of the order sheet. It says both parties order dated 8th February 2023. Both parties file Hazira. Learned advocate for OP submitted that they will not adduce any evidence of OPW. The petition dated will be considered, etc. Order of 8th February 2023. ঠিক আছে দরকার ছিল না ঠিক আছে
What your client has done, what your counterpart has done in the trial court. This is what the cross-examination should come for such a good case.
We can't improve the situation, my lord. Whatever is there, my lord, perhaps because the entire
Are you aware of the AEJ Carapiet's case? Judgment of our High Court.
by Supreme Court.
60 years, 64 years.
Yeah, 1961 Calcutta.
64 years. That's why I said 64 years upheld by Supreme Court. Till date, nobody tried to, my lord, differ from it.
Anything more?
My lord, even on order 41, rule 27.
Your point is very simple. There are two independent agreements. One in relation to a flat at 12.
Triplex flat.
12, 13 and 14th floor, which is of 1980. There is another agreement of 1982 in respect of a terrace flat comprising of 1,000 square feet area. Both have a different or independent rent. So far as the letter of assignment or a letter of transfer, whatever the nomenclature is used, was restricted to a terrace flat. It was never restricted to a triplex one. The triplex one remained with you. And the suit was instituted against a person who was neither a lessee nor a tenant nor nothing. So the decree passed against a third party will not bind the real contracting party.
I have my independent.
You have got a independent right. Your tenancy right is still remain, and therefore the decree is not executable against you.
Okay.
What your case is? Simple.
Absolutely.
Nothing more than that. Where is the letter of the sister? Is it restricted to a terrace?
Sister.
In the additional document.
Wanted to rely on additional evidence?
Yes, my lord. It's page 27 of the can 2, my lord.
Terrace flat. What
is the subject matter?
Same, identical.
Can you take page 27? The subject reads terrace flat number 93 at Trivoli Court.
My lord, that was the submission made, my lord. That was not, my lord, the suggestion was not even given. Now, my lord, I hear that. I was not a part of the suit. ওটা কি সুটে ছিল? সুটের এভিডেন্সেও তো নেই। Yes, and this suggestion, at least this suggestion ought to have been given, my lord. Carapiet again.
The rule of essential justice.
হ্যাঁ। No, definitely, definitely. That is why, my lord, evidence is taken.
আর ওরা রিটেন নোট ফাইল করে বলেছে নাথিং টু প্রুভ ফ্রম দ্যাট কথা বলছে
এতে ফাইল করা আছে and my lord I understand written notes they filed before the court below এখানে কোথায় এর ভেতরে আছে oh that's not my lord included in the compilation it says may I read out
they have nothing to prove
এটা বাড়ে তো
nothing to prove by the decree holder
may I read it out an argument has been advanced that the opposite party decree holder did not adduce evidence and failed to prove as if the onus is upon the decree holder. But there is nothing to prove by the decree holder. No, no, it's not for a moment I'm not saying that, but this continued to be the stand. My lord, so far as my lord the order 41 rule 27 application, my lord, the Supreme Court judgments I can give reference, my lord. Supreme Court has very categorically said that if the court requires. Yes.
Someone who doesn't belong to the house.
Either A or B against
now, my lord, today, if your lordships are pleased to look into, my lord, the documents which they have sought to
Wait 1 minute. Are you giving? Yes.
My evidence, of course, is there, my lord, from the which is why, my lord, they have not paid any rent, my lord. My lord, at the yes, my lord. Totality of facts, your lordship will have to consider. You have the judgment. I know. Yes. My lord, I'll address your lordship on this one.
No, I am not denying. I never denied, my lord. Puri's. No, that's different. That's different.
Can you? You can't put a finger on that. It is only the Puri or anybody who has who is a chance here of the
Kindly allow me, my lord, to think over this, my lord, and address your lordships on. No, address your lordships on the next 5 minutes.
Definitely not. On this ground, Puri remained your lesser. If he has executed by virtue of a registered document, gifted whatever he has, why not?
The agreement, original agreement, my lord, till my lord, the money is repaid. That, my lord, kindly allow me, I shall think over it. I shall think over it. Kindly, my lord, take it.
Unconsignable clause.
And my lord, there was also, my lord, that Supreme Court cases that threat of eviction, my lord, rain tended to the not to the, my lord, to the original landlord, not to the. That's a valid. I shall.
No, never. Never.
Under threat of eviction.
No.
That's what Supreme.
No. Never. Come with the judgment. I will say. Never.
Kindly, may I do it on the next step?
Superior landlord. Who is
Yes.
the superior landlord? Malik's. Malik's are the owners.
Yes.
They executed a lease deed in favor of the Twin World or whatever. What is that?
Tin World.
Twin World has many partners. One of the partners is the Puri. They had an arrangement. The Puri went out. The Puri was allotted this by virtue of an agreement. The Puri has entered into an agreement with you. It is not the Tin World you ever had any agreement.
Very well.
Puri who has executed.
As I
Puri your position.
As I said,
It is a Puri who has gifted the property to them.
kindly allow me to address your lordships on this on the next step.
That I will.
Yes.
We don't know how you'll react to it.
Try to, my lord.
That's not your right. But Mr. Please.
Not my right.
Yes, I'll address your lordship.
Tomorrow. And dictation will be there in the open.
Yes,
No, only difficulty is, my lord, from 2 p.m., my lord.
Or in the first half.
Can it be on Wednesday? Can it be on Wednesday, my lord?
tomorrow.
কি করবো ক্লায়েন্ট কি করবে
Wanted an auspicious day to argue.
করার নেই কি করবো ওরা করবে
That day is an auspicious day.
For me, every day, my lord.
That's why.
Yes.
Fine. Oh, I see. No, second, ये तो कौन लौड़বে কোনো ঠিক থাকে না
First matter বলছো তাকে বুঝতে হবে
কখন
tomorrow.
Tomorrow.